before we get into engineering contracts and unfair terms or the law commission report, if we can just take an example and see there's a contract which is for say road construction. Now in such a contract, what happens is there's a clause that says that suppose if I don't give you complete land access, hindrance free access, you cannot claim damages. Suppose there's a clause which says that let me assume that 15 to 20% additional item of work is added to your scope. You can't claim compensation, it is included in the cost. Let me assume that there's a clause which says that I will appoint the arbitrator if there is a dispute between us, and whoever I appoint, you cannot oppose. Similarly, there can be clauses saying that for extension of time, if I say that I will give you extension of time and you cannot claim damages. Now these are clauses. When these clauses are there in the contract and when the contractor bids for the contract, now he is not really concerned about, okay, what happens if things don't happen according to plan. If he is not concerned about it, then when such a dispute arises, he is probably praying to God that he gets a good lawyer and the lawyer can do something about it. But in a contract of that nature, where the clause is such a nature that it is onerous to one person in the event of default. If there is a negligence on part of one person, but the other person doesn't get compensated for it, then it is deemed to be onerous. Now, this issue is broadly called unfair contractual terms. There are legislations in UK, there are legislations in US, Australia in relation to this. Even in India, we have in the Consumer Protection Act, unfair trade practices can be regulated and consumer forums do have the power to read it down. In case of competition law, we have anti-competitive agreements where certain types of clauses can be read down. But when it comes to pure contractual scenario, we do not have such a situation. Now, Mr. Kavi referred to the 2006 report. The 2006 report had a precursor, which is the 1987 report, which was, I think, the 101st report, which actually went into and suggested a very simple clause. It suggested something called as clause 67A, which said if a contract unfairly imposes burden on one person or does not allow for compensation where in case of another person's default, in such a situation, the clause can be struck down. Now let us take an example where such a clause can be struck down. Now we are dealing with a situation where there are arbitrations, and in those arbitrations the arbitrators are necessarily bound by the terms of the contract. If they are bound by the terms of the contract, then can they strike it down? How do they strike it down? Would it not go against 28(3) of the Arbitration and Conciliation Act? So in this regard, there are some questions which require to be looked into. And one Supreme Court judgment which everyone should have a look at when they have the opportunity is the judgment in Union versus Sarvesh Chopra. So that was a case where actually the Supreme Court looked into the issue. And they said, look here, these kind of clauses where there's a restriction on damage or there's a restriction in terms of claim, that can be there, and that is in fact recognized in Hudson's. But what the Supreme Court carved out a distinction is, Supreme Court said, look here, it doesn't deal with extraordinary gain. It doesn't deal with extraordinarily onerous situations. It is somewhat balanced, is where Supreme Court stopped. And then Supreme Court also said that there are three situations where such a clause can be overcome. So first situation is where the parties renegotiate, which Hassan was dealing with, where parties renegotiate and they say that, okay, fine, we are now going to be bound by certain other terms. Second is during the time of extension of contract or some other nature, if the parties were to say, okay, let us extend the time and allow for claim of damages. Or third, where a contractor, suppose if he is being asked to perform beyond the stipulated period, being asked to do a certain additional amount of term, despite there being a contractual clause which does not permit you to ask for such a claim. If the contractor puts the owner on notice and says, I will do it, provided you give me this much amount as additional compensation. I will do it, provided you allow me this much extra claim amount or this much extra time, so on and so forth. And if the owner does not say anything, then he is put him on notice, and in such a situation, such a clause can be avoided. But typically, the experience has always been that courts have always recognized that the clause, that such a clause will have to be looked into in the way it is. The typical rule in risk allocation, as per the Supreme Court, is you entered into the contract with your eyes wide open. So if you entered into a contract with your eyes wide open, especially in a commercial context, then you are deemed to take the risk insofar as that particular contract stipulation is concerned. You have taken the risk. You knew that, okay, tomorrow if there is a delay in handing over a hindrance to the road, then you are going to face the consequence. You were aware of it. You entered into a contract. So in such a situation, the Supreme Court has definitely taken a view which is more against probably an unfair contractual view, but the courts can't do anything. The courts cannot rework the contracts between the parties in the absence of an expressive stipulation. But there is one distinction. The distinction is when it comes to arbitral clauses. Now, very recently, the Supreme Court in Lombardy Engineering, they said that there's a clause in a contract which says that you should deposit 7% of the amount. And if you deposit 7% of the amount, only then you can make a claim. In section 11, the Supreme Court said, sorry, we can invoke our powers and in terms of either 226 or under 136 of the Constitution and say, no, we will strike it aside. Now, Supreme Court has also struck down certain contractual clauses which it has deemed unfair. The two judgments which immediately come to mind are the Supreme Court judgments in Brojanath Ganguly and the Supreme Court judgment in LIC vs. Scotch. But in both of these cases, the Supreme Court invoked constitutional principles, not civil law principles. So therefore, it becomes extremely difficult for a contractor to really emphasize and find a way around it. Sarvesh Chopra provides one possible way of looking at it, but apart from that, there is no real way. So what then would be the solution? I mean, as a conference, we're looking at how do we find a solution to this entire thing. So the first thing, as Mr. Kavi said, is to look at unfair contractual terms. But then it results in a huge gamut of litigation. Just imagine a situation. An arbitral tribunal is now going to look into what is unfair, what is not unfair, and it looks into it in what context does it look into. So that becomes a problem. So this is where perhaps we should look at more better standard form contracts which are more fair. And the fairness of that particular standard form contract should be tested by an appropriate court or by an appropriate authority which should be designated, rather than leaving the issue to arbitrators or to courts, because then you're dealing with a situation where there are going to be large amounts of inconsistencies. Because courts are not dealing with contracts in vacuum. Courts are dealing with contracts in context of the dispute. So if the dispute results in a situation where a particular interpretation is required, a court is mindful of that, and in that context it is interpreted. But then one interpretation leads to a further interpretation, and then we go down a path where we are dealing with situations where even slightly onerous terms become disputed. So therefore, my suggestion would be to look at a situation where standard contracts like FIDIC and such other contracts are more encouraged by the government and not have one-sided contracts. Thank you. Thank you.
The problem with Brojanath Ganguly is that it was for service contracts and not for commercial contracts. And this disclaimer is there in the judgment itself. And there are subsequent judgments where it says that does not apply to commercial contracts. Now, only idea is that Supreme Court may strike down, but whether arbitrator can strike down terms of contract. And unless it says it is void and there is part of pleading. I would only say one thing: if you see the amendment in section 28(3) in the Arbitration Act 2015 and the Sanyong judgment subsequently, this 28(3) has been diluted. SOPA has been statutorily overruled following 246 Constitution. And then this 28(1)(a) of the NC Act has a mandate and duty as well on the arbitrator to decide as per the substantive law of India. India contract is a substantive law. And there I find when we follow English common law, even English law, common law principles where the parties make their own contract, but then when there is a statute, then parties cannot make their own contract override in the statute. So why Indian Contract Act can be overruled by parties' contract? Because we have a code here, section 53, 54, 73. Can that be overruled? Okay, no, Sarvesh Chopra gave this first window, but then these three escape routes was for that period qualified that this is the principle in common law, then says, however, in India the law is governed by section 55 and 73. I don't know those three exit routes do apply in India or not as per the judgment. So it is service proper is incomplete in many ways. Then it goes to section 55. I understand different people follow the entire judgments. If there is a prohibition in the contract, like extension of time is the only remedy and not damages, then possibly while seeking extension of time, the party has to reserve a space between them. So with that, I will go to the next speaker and he can do the Pradeep.
Already there.
And that is on a very interesting topic on subcontracts and consultancy contracts, which are often not discussed. And these are very, very complicated compared to normal contracts. I hand over to Mr. Pradeep first. And maybe I have not got questions, we'll cut down the question and answer session for possibility of time and maybe take a few questions. Thank you. Sorry, sir, you can pass on questions. We can't take time, we don't have time to take questions.
No, write it down. We'll take the questions. Write it down. Not verbally. Sorry.
Up ಮಾಡ್ತೀನಿ ಸರ್, ಅಪ್ ಮಾಡ್ತೀನಿ. 30 seconds.
Anytime we talk about contracts,
Up ಮಾಡಿದ್ದೀನಿ
it's not
ಸರ್,
just the
ಕನ್ಸೋಲ್ ಆನ್
document,
ಮಾಡಿ.
what we have written, but even the conduct of the parties
Okay.
is important. So subcontracts, what happens? Sometimes the contract prohibits subcontract. In that case, if a party has taken a subcontract, is that valid? Maybe on the first day you can always argue that, but after you have completed a substantial portion of your work, what happens? Are you entitled to your fees or not? Is it illegal? Can it be void or voidable? These are the questions that arise. So, again, there is no clarity. All the topics that I talked today are in the grey area, the twilight zone. We don't know what's happening. Courts have held in those particular facts and circumstances, the subcontractor is entitled to payment. In certain cases, they said that is not allowed. So one such an example is if the government department was aware of the subcontractor's presence. Later on, the government department cannot raise the issue that subcontracting was not possible. What if the subcontractor did not know these conditions? So these are the concerns I'm talking in this slide from the subcontractor's point of view. Clauses such as pay or pay when paid. Again, to a reasonable extent, courts have held those things to be valued. What is reasonable? Again, gray area, the twilight zone. Now, subcontractor may have taken some work on lump sum basis, but the designs are changed midway. Now, instead of silver, he has to provide gold. Then what happens? We don't have an answer. The dead weight contracts, that is the biggest thing we don't talk about. This is not only for subcontracts, for everything. I have reserved you, saying that if or when I call you, you will come and perform. But there is no consideration if you don't perform. But if I call you and you don't perform, I am going to penalize you so much. So you're just sitting idle. There is no contract between us because I have not yet called you. We only have a memorandum of understanding. So these are the kind of problems that subcontractors face. Now from the contractor's point of view, what if the subcontractor defaults? Does he have enough resources so that I can go after and get the damages? I have 100 crore paying. The subcontractor is having assets worth only 5 crores. Then what happens? Similarly, if the subcontractor causes some kind of accident in the site, am I responsible? Should I take insurance for that? Will my insurance cover that? These are questions. And what if the subcontractor doesn't perform properly? Do I have to demolish everything, reconstruct at my cost and then get it back, the substituted performance, or claim damages? So these are concerns where the contractor doesn't know how to handle it. From the employer's perspective, can he say that the employer is liable to the subcontractor even though there's no privity of contract between the employer and the subcontractor? Because everything is being channeled to the contractor. Is there a difference when we get into public domain and private domain in terms of law? Well, courts have held in certain circumstances that the government authority is liable to pay the subcontractor even though there are no privity of contract. Everything, as I say, is a grey area, depends on the particular facts and circumstances. And statutory compliances, taxes, that is the biggest problem. Our tax laws, Manipal Law has said in the days itself that within 3 years of implementing our tax laws, we had more cases filed in India than the entire cases that were filed in UK. So that is how complex, and I don't know why they write these kind of laws. The employer, whoever it is, or the contractor, whoever it is liable for the inactions of the person below him, the subcontractor. How do I know that? How do I track that? I don't know. Now, if I know that somebody is working, should I continue with them or knowing that they are illegal with them? I don't have an answer once again. Now we use these terms, back-to-back contracts. What is that? It's not a term that is defined anywhere. Is he a financer for you? Is he a subcontractor? Is he your contract manager? Is he your insurance providing you the indemnity? We don't know once again. So this is all situations where now can you pass on your liability to somebody else? Courts have allowed that you can pass on your obligations and duties to certain persons, but what about liabilities? Based on particular facts and circumstances, that is allowed. What if there is an arbitration clause in the main contract and you have given it the back-to-back contract? Will that arbitration clause also get carried over? Most likely no, and I'll leave it there. Consultancy contracts. From a consultant's point of view, is the consultant really independent? Because who is going to pay him? Should I listen to my boss who's paying me, or am I really independent? Can I rewrite a contract? Is it a point, something like that, is so important as part of my duty that I give instructions, which is constituted as a modification of the contract clauses? Rewriting of the contract? I don't know. How do I balance the contractor and my boss's directions? Contract is concerned about the consultant. What if the consultant provides a bad design? As a contractor, I am supposed to get the engineering designs proof checked by somebody else. What if the building collapses tomorrow? Am I liable? Because I am the first vendor to be arrested. So that's a concern of these contractors. Employer. Usually, when a consultant is hired, there is a limit on the damages of the consultant. 10% of the consultant's fees. Come on, I'm building a 100 crore project. If the building collapses, I paid the consultant 1 crore. He's going to pay me 10 lakhs because of his fault. What if the consultant is just copy pasting and not doing any value engineering? The column in the ground floor is this big, and even on the top floor, it's the same design. Logically, it has to be smaller. So these are questions which are again in the gray area, and it's a learning process. As of now, it's not defined. With that, I just thank you.
Thank you, Dr. Reddy. And I don't have questions from the audience with me, so I will have take few questions. And within maybe maximum 10 minutes, I will close it. Like any question is coming in between, I will ask Mr. Seth, should there be planned renegotiation of contracts, given the realities of long-term PPP contracts?
I think so, because 20 and 30-year periods are too long to forecast in terms of what different situations may arise. So it may be worthwhile to have some renegotiation mechanisms built into it, which are fair and upfront. And as I had shown, like NHS explaining contract, already either automatic or like subject to negotiation mechanisms already built in. So it's worthwhile to expand these things instead of presuming that there would not be any need to renegotiate, and if required, then as per mutual bargaining.
I think we have a question from Honorable Justice Bhatt, so kindly sir.
Thank you. I'm sorry for not having articulated it earlier. I'll try to make it brief. It is to Mr. Vijay. Taking the thought further from your comment, and I thought it was very useful that stability in the law is needed, and the issues that you spoke about are essentially issues of policy. And you have highlighted the gray area and, let's say, gaps in the law. Now, how much has this area
been explored in terms of hard contract law in section 23 and 27, particularly section 27, because these are restrictive covenants in the sense that those conditions which impose restrictions on the claims, the kind of or character of claims. One is the Sarvesh Chopra route, which takes an extraordinary, it takes a leap out of contract. Now, within the contract, we have special conditions which limit damages or limit interest. Now, I remember in the area of insurance, some of these restrictive practices, the courts have overgone. I remember authoring a judgment early on as a judge where an insurance claimant, mercantile insurance claimant who claimed a substantial amount, was made to sign and say, this is in full and final satisfaction. So, facing the Indian law, the court we said that this cannot be insisted upon, this is not voluntary. So, at the root of every contract is voluntariness. And when we talk of standard form contracts, which I think some jurisdictions define as contract derivation, there is an inherent unfairness in certain terms. So, how has this area been explored? Has it been explored?
Sir, insofar as insurance contracts are concerned, especially consumer forums, when they have looked at it, they have definitely read it and they have brought an element of fairness. Now, insofar as commercial contracts are concerned, sir, to my limited knowledge, sir, what has happened is that the courts look at it from two perspectives. One is they apply the contra preferendum rule, so they get into contractual interpretation. So they say that, look here, if there is an ambiguity between two clauses, so suppose if there's a clause which says that you must pay within 15 days, and there's also a clause which says that if I don't pay you, you have no right to claim damages. The courts have found some level of inconsistency, not necessarily the Supreme Court, sir, but other high courts have found some level of inconsistencies, and they've said no, you must pay some amount as interest. There is some amount of unfairness, and they've brought in unjust enrichment in such situations. Another situation is also they bring in the blue pencil rule, and they say that okay, this clause has to be interpreted in context of this. So this is one set, sir. Then another set is when it comes to anti-competitive agreements. That's where some principles which are applied, they are very useful for even commercial context. And that is where, sir, I think section 27 context has been more explored in more detail, but unfortunately not in commercial contracts.
Mr. Kavi, I have one observation on what Pradeep was talking about, and he was talking about grey areas, and two grey areas he talked about. First being that how to align the interests of the prime contractor or general contractor and the subcontractor in relation to two set of disputes, one being between the employer and the prime contractor, and second being prime contractor and the subcontractor. Answer lies in aligning the contract document itself. And for that, the best solution you can find is in FIDIC subcontracting form of 2011. And I had occasion to talk about this form way back 2014 when FIDIC and ICC had done this conference in India for the first time. This contract form talks about alignment of the interests, but again, parties should be aware of this subcontracting form. That is one. Second gray area, you talked about back-to-back contract. Globally, back-to-back contracts are of two types. One is pay-when paid clauses, and another is pay-if paid clauses. And particularly in US, in all states, they have this differentiation between two set of clauses. If your contract between the contractor and subcontractor is worded in such a fashion that it is not a precondition that the prime contractor will pay only when it gets the payment, unless it is worded very strictly, he is not supposed to pay immediately. But if it is a case of it, so in that case he is not supposed to pay at all. But if it is a case of pay when paid, then in that case within reasonable time, main contractor has to pay to the subcontractor. In fact, Delhi High Court in recent judgment has without getting into this, has said something on this line. And another bigger difficulty for this main contractor is, in which are generally the government bodies and the public sectors, they take the contracts and they then give on the subcontracting basis entire work to somebody else. On the side, subcontractor is working. Whatever complaints subcontractor will have, all of them are sent to the principal employer by the main contractor and the principal contractor. Now, when they go in dispute, the subcontractor will cite all those letters which main contractor have written to the principal employer, and saying that you are yourself saying that subcontractor is not at fault. How to go about this? Only one case which you have in India was argued by me in Delhi High Court, that is telecommunication, TCIL versus NGPS. There I had said that in situations like this where subcontractor is doing the whole work, in that case what main contractor does is it is working just like a post office. It is just passing on whatever comes to their hands to the principal employer, therefore it should not be read against. So these were some observations on your gray areas.
Thank you, Mr. Singh. It's very, very enlightening. And I think we do not have time, so my apology. So many questions I pass on to the speakers, and they will answer. I will answer in one or two sentences. One question from Mr. Abhishek Tiwari. How can we, owner of stroke contractor, claim consequential damages if there is no such provision under the contract? If I understand, Section 73 of Indian Contract Act, there is an issue of two liens, and the consequential damages refer to the second lien, if I am correct. So when, even if it is barred consequential damages, then it doesn't bar what naturally arises under the first lien. So the question may be framed in a different way. Rather, if there is a claim of consequential damages in that sense, then Section 73 following handling of succession by 5488 requires knowledge of the parties. Of course, Victoria Laundry 1949 subsequently, and of course, I understand knowledge can be imputed. It might not be always expressed. And I think with that, I am extremely sorry. I will not able to answer all the other questions, and we have to go to the next sessions. We are delayed by more than 1 hour, 10 minutes. So thank you, everybody.
Thanks to the moderator and the panelists. Now it's time for us to convey our deep gratitude for the excellent deliberations that have happened. So may I request Mr. Lakshmanan Ramaya, the General Manager from L&T Heavy Civil Infrastructure, to please come out to the stage to felicitate our distinguished speakers. So may I request you to first facilitate the moderator, Mr. Ram. I request all the audience to please applaud our distinguished moderator. Thank you, sir. May I request Mr. Hasid Singh to please accept. Thank you, Mr. Hasid Singh, for the excellent views that you shared with us. Thank you, sir. Mr. Badrinath was as eloquent as ever in his sharing of views. Mr. Ajay. Thank you, sir. Please extend a loud applause to Mr. Ajay. Thank you. And then we have Dr. Pradeep Reddy from IIT Hyderabad. Thanks once again to the distinguished panelists. Now we will move on to the second session, which has for theme Mastering Administration from Groundbreaking to Handover. May I request the panelists of the second session, the moderator is Mr. Asit Singh, and the panelists are Mr. Kavi, Dr. Sridhar Anilal, Mr. Sampath Raman, Mr. Lakshmanan, and Nitya Bansal. I request all of you to please take your seats on the dais.
ಯಾರು ಏನಾಯ್ತು ಇವಾಗ ಅದರ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಯ್ತಾ ಇಲ್ಲ ತಾನೆ ಡಿಸ್ಕನೆಕ್ಟ್
This is the order in which this slide should come. Session 1.
It's on. It's already ready. Just, let us know the names.
Order.
I will take care of it.
Well, good afternoon. We have the panel settled ID, and in the second session, instead of introducing each speaker whose introduction you already have in the printed form, in the interest of time, you can just look at the printed material for their introductions. The session 2 is about mastering administration from groundbreaking to handover. There's a lot of things that happen right from when like the project groundbreaking happens to progress. What really is going on is a planned version of it in the contract as it was thought that how it will play out and on the ground situation, and there is always a delta between both those things. And a lot of contract administration work is about managing this delta. If it's managed in harmonious manner, the progress happens, and the end result is a good work product. And minor adjustments along the process. It's also almost impossible that what was planned actually happens at the end. So, without much further ado, may I invite Ganesh Kavi sir to actually deliver his talk He's going to talk about extensions of time and essentially LDs and extensions of time and some critical issues around it. So, Ganesh, please.
So we have a very large panel, so I will be very quick and it's a very age-old topic and discuss again and again. But still, we have issues on that. Can you load the PPT, please? Yeah. First question. Why an EOT clause? And what happens if there is no EOT clause? If there is no EOT clause, then contractors shall not be excused for non-performance and shall be liable to LD. Mostly I will confine to EOT versus LD and not the other entire gamut of it. And if there is no EOT clause, if the employer is prevents or responsible for found to be under prevention principle, then it will be disentitled to any LD even for the delays caused by the contractors. And it may happen in certain events, even the contract may not survive. So the EOT clause is for the benefit of the contract, for the contractor, as well as for the employer. What happens is actually the next slide and my experience in India. There are two requirements. Firstly, the EOT clause should be adequate. It should provide for all the contingencies for all preventions. Second part is that it must be operated. So either if it is inadequate or it is not operated, then time shall be set at large. And that is the case in India, where most EOT clauses are adequate, but EOT clauses are not operated. Either the contractor does not apply EOT as required under the contract, or the employer does not give the extension of time as required. There is almost a cancer in India of provisional extension of time in breach of the contract. And that sets time at large and employer loses its right to put LD. So the operation of extension of time is important. SCL protocol, Mr. Singh highlighted in the morning, it also prescribes the contemporaneous extension of time and not retrospective extension of time. Here we have a typical problem in India where the extension of time given by employer and provisionally extended without prejudice to the right to levy liquidated damages and an NDMC versus IGN case Delhi High Court had. If you give provisional extension, the only thing you can do, you can give further extension. And no LD can be imposed till that date. And that happens, and in India, 90+% cases, LD fails on that account. Now, whether LD can be imposed post determination of contract, of course, yes. There is no prohibition under the law or under the contract. If you go to the authorities, including Hudson or Julian Bailey, they provide unless contract prohibits, then this right is there. But the problem is not that right to put LD post determination. The problem is this: people, mostly employers, confuse between LD and extension of time. Maybe extension of time cannot be operated retrospectively, and if that cannot be done, the LD goes. So there has to be a fine distinction to be made. CPWD in 2017 has reserved his right to put LD post determination of contract, but that CPWD does not permit retrospective extension of time. And there is a specific provisions of clause 5.5 which requires this extension of time to be clearly notified with liability of the contractor, and that is required contemporaneous. That is never done. In my own experience in huge number of cases in arbitration and CPWD. Next is that whether condition precedent, I think Mr. Julian Bailey has something to say on that, I understand, in his LinkedIn, so I will not touch on that much. And he is talking about Gulf and as well as India. He is referring to section 28B. I am only telling one more point here that in addition to 28B, where with the conflict between the prevention principle and the condition precedent, can employer prevent the performance of the contract. And suppose asking or seeking an extension of time by the contractor is a condition precedent, then can employer levy LD for its own delays? And I think English law and Australian law are different on that. English law upholds still the prevention principle, or it is probably other way around, Australia and England. But in India, I think prevention principle is also codified in section 53 and 54, and I think general notion and prevailing thing is that no, the prevention principle shall override the condition precedent things. And of course, if a contract has a provision, even without application by the contractor, employer has a right, then it is not a condition precedent. And now, regarding LD, I will be very short considering the time, and I will tell the basic principles you know. Under Section 74 Indian Contract Act, it is, law in LD is distinct from English common law. We don't distinguish between LD and penalty in that sense. Under Section 74, loss must be proved, whether it is LD or penalty, if it can be proved. Either way, and whatever is specified, whether it is a LD or penalty, LD word is not used Section 74, then it is the maximum amount. And there is a huge amount of judgments, and that is the maximum amount generally, which of course there are such instances where it can be exceeded. But I don't have time now to discuss. You can take in question and answer session. And there is a quite good number of judgments from Arjun Singh versus Panna Singh 1929, earlier Privy Council judgments, and then Nilal Mehta, then Fateh Chand versus Mola, then Mola Box, 3 judges, and I think Fateh Chand, 5 judges still holds good. And then of course SOPA is little variant, but then Kailasnath Associates and Design Contractors and many other judgments. I have given this in PPT next so to share with the audience and anybody want, but I am not dealing with this considering the time shortage. And my conclusion are that this can be read here, and I will close with that. That it must be, your clause must be operated properly, and then it saves, and the commercial purpose of LD will survive. Probably that we have taken a highly legalistic view of time set at large and everything, then what is the advantage of LD clause for the employer? And that question must be answered. And the way LD clauses fail, I think the employer does not get any benefit of the LD clause. Thank you so much.
Thank you, Mr. Kavi. May I invite Mr. Lakshman from L&T to be the next speaker. He's going to talk about use of artificial intelligence in contract management and administration, given the vast amount of contracts which Larsen & Toubro administers. So, Mr. Lakshman.
Thank you, Rashid. Could I have my presentation? So, the moderator said introductions apart. I'll delve into the topic straight away. Artificial intelligence is our third subject. So, I'm going to share as a contractor what we really do in artificial intelligence and what we think as artificial intelligence and how do we capitalize it. So how it all started is before 3 years we were carefully observing what Amazon and Flipkart does exactly. So they use big data of a human and then they try to match with experience and then they started selling products and I do not know it's good or bad. We are victim of Amazons and Flipkarts because they exactly track our experiences. It's using data, simply data. Whenever you feed in, they get to match with your experience. For example, what they could do today is a funky husband who wants to buy a gift on Valentine's Day can be diverted to buy Pampers for his kid by showing an experience. This is what happens with Amazon and Flipkart. So we started believing, why don't we do that with the customer experience? It's a data. L&T is a big company. We are 7-decade-old company. We have strong database of customers, the experiences. So we started collecting as a repository, and then we started doing some sentiment analysis. So that's how it all started. We started with AI, and then we started making a repository. And you all will agree that data is the fuel to artificial intelligence. So what happens precisely in artificial intelligence is what you see here. Data inputs used as a data source and a repository, making sense of the data, and then mimicking it so that the machine understands the experience. This is what we are doing now. We are not to the full scale, but this is how we started. We are there about 10-15%, and we need to go long way. So what all I am talking is not proven and sharing what we are doing. Getting into the applications that large language model does is now we heavily rely on drone technology. So every of our project is monitored using drone technology. So we have big data on the progress, what exactly happens day in day out. So if any dispute comes, we'll be easily able to picturize what really happened. Today, evidence is becoming important topic, like 65B, digital evidence, and all those things. We are unsure. When I was in Cambridge, the question of usage of building information modeling as evidence was heavily discussed. So we are not sure how the law supports us. So a building information modeling basically captures everything. It's easy to find out, but how the law supports, I mean, law has to evolve in my view. So now, as such, what we do in construction, per se, last and my division is we heavily rely on drone generative design, all those computer vision. We use Azure as a platform, and then on building information, we have gone up to asset management. We call it Bing Bang Bomb, building information modeling, building operations, and building asset management. So we have gone to that. On extension of time, traditional way was to use MSPs and primaveras. Now we have advanced to something called DCMA 14 check to get the logics proper in the base program. And then we have advanced to usage of Steelray and softwares like that to really test the integrity of what people are talking. That means there are softwares today which can test and do the forensic, which we are also in heavily. And per se on contracts management, we also get into document management systems, branch, and all those platforms. So this is what we do. And exclusively on dispute management, my colleague, Madam Nitya, will talk more. And we are also into that, specifically on DABs and arbitration management. We rely on certain softwares. So what all I am trying to tell here is different set of data from the pool to make sense, to apply to different tools to get different type of experience to the customer. So this is what I'm talking about. Now, while resolving disputes, more of data backup and evidencing was always found to be helpful. For example, in last 3 years, I have been able to resolve about 4,000 crores worth of disputes without getting into arbitration. It's just showing the customer what is the right picture. I'm only duplicating and cut copy paste of what Amazons and Flipkarts are doing. Put the right data, right time to right person who has authority. Explain him. Once they get to that position, instead of a funky husband, he becomes a father of a kid. So that's how I get money. It's worth of clap for me. So this is what I'm doing. This is exactly what we are doing with big data, and data will support us what to tell the integrity of large language model as nation builders, what we did, how we did, completely showing them the evidence changes the position. And I'm advocate of early neutral evaluation technique, ENE technique, which my fond subject. I'm fond of that subject. I use early neutral evaluation technique to show the customer both positions and fully backed up by AI. So we were so successful, but we are still laggards and very primitive, simply copying Amazons and Flipkarts what they do with user experience. So when I say user experience, I go by customer experience, our customers. So when you talk about specifically contracts management, risk management, extension of time, and dispute, we face some common problems. The common problems I have displayed here is holding a central repository and then triggering reminders, monitoring milestones, key dates is the common problem for the all sets. And there are specific problems to each of these domains. Like contracts management has a very unique one project in Bhutan I'm doing for almost 2009. It started, it has not ended now. So construction contracts are very long span. So data repository becomes very important for our contract management. And data rigging and then making sense of data is one key thing. So we try to segment the specific problems to each of the domains, which is what you see. If I have to elaborate, the time given is not sufficient, so it's there on the screen. So now later, today we are talking about cyber security. We have a big security threat. Data security is one important topic being spoken. So last month you bro consciously was supposed to decide whether to go for a standard software or tailor-made one. So it's a very tough decision. There are very sophisticated softwares which can be procured and used, but data security is a question mark. So we were in a dilemma, like we got to develop products or we have to use standardized products. We decided no, go for both. Mix and match. Go for both. So in our cloud servers, we plug in the softwares. We today have our own website, separate website, which has all these plugins. So what you see here is converted in this way. So these are the softwares which we use as a plugin, and then we have our own controls to control the data security. Now, we call this as a single ecosystem where large language group behaves everything collated, single data source, big data source, which traces and gives sense to different customer experience right from the inception of tender stage. So tender to completion of project, I can pull out and color the data for different customer experiences that we want. So now this is a short.
The PDF video will not play.
This video, no, this is a, no, this is okay. This is a PDF.
You have video embedded?
Yes.
Yeah.
No,
Only the PDF.
That is video.
We don't have server.
So now when I say infrastructure disputes, for us, whenever at the start you see it's a customer interface. That's what I call. So the disputes can arise at pre-bid stage, post-award stage, right on the date of project award, execution stage, and then we have project finish, maintenance period, and closeout stage. So for each of it, we think that the data set should be different, evidence should be different, how you communicate should be different. So an artificial intelligence will help to mix match based on what algorithms we code in Python. So this is what we are doing. As of now, we have some strong Python codings, which has passed repository with the same customer, how the experience was, and then what is the subject matter. Is it happening on execution stage, pre-tender stage? Where is it? For example, pre-tender, how many writs has been filed against this particular employer? How was the relation? What we did for them? Everything comes into picture. So to handle such a kind of big data, I'm simply duplicating the range of Amazon. What we are handling compared to Amazon and Flipkart, we are only 1% of what they are doing. So what I'm here to say is infrastructure is a baby compared to Amazon. We only need to untap the artificial intelligence and we simply mimic them. The value that we get will be phenomenal and the dispute resolution is going to be fantastic. And I have strongly followed Arcadis research, which says that the dispute at 2030 in India is going to be 96 lakh crores rupees. Therefore, artificial intelligence is not going to remove the disputes. It is going to enhance dispute resolution. Why? Because for the simple say, if somebody is winning, there must be somebody to lose. Therefore, dispute will be there. And the value also has been calculated. And India and Gulf is going to be the primary market of dispute. And it is justified that our GDP is going to be skyrocketing. So the countries that is going to go with high GDPs will roll out fast-track contracts, which will have ambiguity, and resolution is a must. So therefore, dispute will be there despite artificial intelligence. And this is one way where I think the customers and employers and contractors can be happy in resolving the disputes. It need not be a painful process, provided it should be backed up with the superior evidencing and slight tweaking of laws on application of drone, accepting drone videos as evidence, application of photography imagery as an evidence, so those things, if the law is slightly tweaked to allow billing information modeling to be accepted as an evidence, then the pain points will reduce. This is what we found from the application, at least my personal experience in resolving disputes where AI has been supporting to me all the conclusion is, you would see that originally the earlier concept dispute management was kept outside contract management, and then later part we have brought in DAVs, amicable settlement, multi-tier dispute resolution, which is still not working out, and still it extends the time as if it was original. And future, we think it's going to be strongly coupled with artificial intelligence, with heavy customer experience, which Amazons and Flipkarts are doing. And that's what I have to say as last minute review. Thank you very much.
Thank you, Mr. Lakshmanan. Next I'm inviting Anirudh Krishnan from AK Law. He's going to talk about suspension and termination in contracts and legal aspects around it. Anirudh.
Thank you very much, Mr. Seth. While I have a presentation, I'm not going to go with it because I'm given to understand we have about 6 to 7 minutes time each. So if I go into that, that'll take much longer. So you don't have to do that. So when you look at suspension and termination of contracts, specifically the construction contracts scenario, the first question is, where does the right to suspend or where does the right to terminate arise from? Now, I think the difference between suspension and termination is very obvious. Suspension is suspension of works or part of the works for a certain amount of time. Termination is bringing the contract to an end. So where does the right arise from? The right can either arise from the contract or under law. Now, insofar as the right arising from contract is concerned, I'm not going to go into it in great detail because it obviously depends on the terms of the contract. I will probably set out some broad generalizations, but I will not be going into that in great detail. What about the right under law? So let me start with termination. There can be two sources under law, under the Indian Contract Act, to terminate a contract. The first is Section 39 and the second is Section 55. Now let me deal with Section 55 first because that arises much more commonly when there are delays. Now what Section 55 provides is that in a contract where time is of the essence, if the timeline is not met, the party which is affected by the delays has a right to terminate and also claim compensation. In a contract where time is not of the essence, there is no right to terminate but only a right to claim compensation. That's the sum and substance of Section 55. The issue then is, when is time of the essence? Most construction contracts will contain a term saying that time is of the essence of the contract. But these contracts will also contain a term for extension of time. They will also contain a liquidated damages clause. Now the Supreme Court interpreting these clauses has held that where you have an extension of time clause and where you have a liquidated damages clause, the intention appears to be that there might be delays and the consequence of that will be an extension of time. Consequently, in contracts of this nature, even if there is an express stipulation that time is of the essence, time is presumed not to be of the essence. Therefore, by default, in a construction contract, if there is the contract is to be concluded in 2 years, it is not. By default, there is no right to terminate under section 55. However, the question then is, what if it goes on endlessly? 2 years becomes 5 years, 6 years. Are the parties remediless? That is where a contractor can make time of the essence. Either party can do so, not just the contractor, but usually, so what the contractor should then do is write a letter pointing out as to how it's already taken this far and why time becomes of the essence for the next, say, 3 months or 4 months, and how if certain acts are not done by then, they will go ahead and terminate. Once time is made of the essence, then the right to terminate under section 55 would again accrue. So this, in sum and substance, is the right to terminate under section 55. Section 39, on the other hand, would arise in far more extreme situations where a party does not perform its contractual obligations in its entirety or absolves itself from performing its contractual obligations in its entirety. Now, a simple breach will not give rise to a right to terminate under section 39. It will only be a repudiatory breach, that is a breach that is of such nature that is covered by section 39, that is a breach, a disabling of a party to perform its obligations in its entirety. So a typical scenario would be something like an abandonment. So if the contractor abandons the site over a certain period, then perhaps section 39 can kick in. But it's very rare in a construction scenario for section 39 to actually be invoked. It may be in a scenario where the construction contract, land is to be handed over for a period of 15 months, even the land is not handed over. Then it is possible for a contractor to invoke section 39. From an employer's point of view, abandonment may be a scenario. So these broadly are the rights under law to terminate a contract. Now, coming to the right to suspend a contract, you will not see the language of suspension used. But if there are reciprocal obligations and party A has to perform obligation A, followed by party B having to perform obligation B, and party A does not perform its obligation A, then party B need not perform obligation B and it's absolved from doing so. So in such a scenario, if there is a breach of a reciprocal promise by one party, then the other party has a right to suspend its obligations. It need not, it's absolved from performing its obligations. Now, reciprocal promises are either promises where the latter promise cannot be performed in the absence of the first being performed. So, for instance, you look at a scenario where land is not provided, you cannot commence works. So, therefore, that would be a reciprocal promise. The second is where the performance cannot be claimed of the latter if the former is not performed. Now, these are contractually induced reciprocal promises. So, for instance, if there might be a term in the contract which says that if there is no payment that is made for a certain amount of time, the contractor need not go ahead and perform the works. Then that would come under the second category of reciprocal promises. Because without the money, the contractor can still go ahead and physically perform the works. But performance of the latter cannot be claimed without the performance of the firm. So these are the two categories. So therefore, under law, the right to suspend is something that I would locate within section 54. Now, briefly touching upon the rights under the contract, obviously these are very contract specific, therefore I can't come up with a broad generalization. But a lot of contracts, whether it may be the FIDIC contracts or even the CPWD contracts, provide for a right of suspension, provide for suspension at the instance of the employer. So usually there is a requirement that the employer notify suspension. But if the suspension continues beyond a particular time, then the contractor usually is given a right to terminate. So under the FIDIC it's usually 84 days, CPWD says 3 months. Then thereafter the contractor has to notify the employer that the employer needs to sort of cure the suspension or within a period of 28 days or 30 days, and thereafter a right to terminate accrues. This is usually the language that is there in many of the construction contracts, but this is of course, this can vary. So for the right to terminate, you will see most contracts only provide the employer a direct right to terminate. These would be upon a material breach, upon the contractor going into insolvency. There are various factors that can be there. But practically, you will not see in many projects there being a case of termination. Even suspension is rare because usually the suspension is at the instance of the employer and the employer never goes. Yeah. So briefly, let me touch upon the consequences in one minute, and then I will wrap up. So, if there is a termination, what is it that the contractor can do? What is it that the employer can do? The contractor, if he proves that the termination by the employer is illegal, or if the termination is by the contractor and it is legal, then the contractor can claim loss of profits for the balance portion of the works that was not completed. This loss of profits is different from the loss of profit earning capacity, which would come up where you claim delay damages, where there are multiple other conditions that have to be satisfied based on just Ravindra Bhatt's recent judgment in Unipros. This, when there is a termination, you can claim loss of profit as a contractor. From an employer's point of view, they terminate if they can show that the termination by the contractor is illegal or that the termination by the employer is legal, then they can make a risk and cost claim. They engage another contractor to do the same work and claim the difference in cost. Thank you very much.
Thank you, Anirudh. May I now invite Mr. Sampath Ramanji to essentially discuss his topic is about interim and final payments during the progress and completion of the contracts. Respected audiences and speakers, come across eminent speakers, advocates. This is very interesting. I'm going to discuss about more of management aspect of construction contract rather than the process and sub-process of the contract. I just tell you an interesting context to make it a bit more lively. We had secured one project management services contract and then me and my boss say, my boss said to the client, say, look, we are management, we are meant for managing projects, and then we don't want to, if you manage efficiently, we don't need conditions of contract to be invoked every time. And then the client representative said, look, I got one advice to give it to you. He said, there are two things in the construction contract. One is managing various stakeholders. Second is implementing or administering the contract through the conditions. He said the first one, managing the various stakeholders, is relationship building, managing the various stakeholder relationships. And he said that's Ministry of Foreign Affairs. And then the second one, he said, what happens if the relationship fails? We should invoke Ministry of Defense. So I still remember that particular statement. I always believe in that. And
we all operate conditions for contract. We do have to manage relationships, and at the same time, we know that the conditions of contract with the Ministry of Defence. So if it fails, we remove that. Okay. With that, I will start my quick discussion on this interview final payments. So the first one is about original program. It's okay. Everybody seeing the picture? So contractors program and progress. It's fine. Tender program and contract program. Everybody will be looking at what is tender program, what is contract program. So look at when the contract is, everyone is familiar with. When the contract is awarded, the contractor requires that the conditions of contract within certain time period to submit a contract program under clause, whatever conditions of contract. What is the significance of tender program? So the important thing I would reckon is that when you finalize the contract for award, prior to award, the contractor submits his final price and is based on the final program and things. So that contains the details of what the contractor's tender program is. So the contract program needs to be aligning with the tender program in terms of the timelines overall. The tender program will be brief, but the contract program formed after the contract is submitted after the contract in detail. Okay, and any revised programs, if there is a progress is not affecting the program, the contractor, if he is in delay, he has to submit a revised program. Everybody is familiar with the conditions of contract requirement to submit a revised program. Okay, but this again, the management aspect of it is we don't need to sit and wait for contractor to give delaying and then writing a contractual letter and like invoking again Ministry of Defence. So we can be proactive, managing relationship in progress meetings. We can say the contractor you delayed. So where's your recovery program? So that's management aspect of it rather than waiting to writing few contractual letters. Other important aspect which I believe cash is the king in projects, and most of the problems which contractors come across is cash. So the cash flow, it should be paid at the right time, at the right opportunity as per the conditions of contract. But again, there is a lot of management aspect to it. So one of the things which we followed in the construction contract is cost loaded program, where actually we have asked the contractor to load the program, construction program with cost. So a simple example of it is that if you got 20-floor building, so you load every floor completion of structure with a cost. So the progress and the cost is loaded together, and then the valuation of the monthly valuation contractors thing is easier. It's done quickly and faster, and there is better understanding. It helps the cash flow of the contractor. Okay. The other aspect is about time for completion. It's about date of commencement, its significance. Again, from management aspect of it, there should be clarity when the contract is formed. Date of commencement, what is it? Which should define clearly. There are issues like date of commencement if it's not defined. Some cases where the contract is awarded, the date of commencement is mentioned as such and such, and then the contractor is not able to commence either because he doesn't have the access to site or he doesn't have the required authority approvals, no objection certificates whatsoever, and then the problem starts. So there is a delay claim and all that. So there are some contracts where we look at this aspect and for better management, we said certain cases, the date of commencement is such and such date. However, if the contractors delayed because of not obtaining the no objection certificate, which is the authority requirement, where the contractor doesn't have control. So then, upon receipt of the NOC, straight away you review it and award an extension of time. Okay, which is I'm talking purely from management angle again. So we don't need to allow this to bleed, and there is no provision. So if you build in the provision in the construction contract that in the event of NOC not available, and certain cases the client is not sure about when the access to the site will be given. So you can define this access to site will be given such and such date. If you are clear about it, that can avoid possibility of contractor, standing in a position where he hasn't got and he has a delay kicking in. Okay. The other item I want to discuss about the interim progress payments. So in interim progress payment, again, from management point of view, we need to look at how it can help the contractor in terms of cash flow. So contract, everybody knows contract value. And then the problem starts with a lot of variations kicking in the contract. When you contract is awarded, subsequently a lot of changes happen, variations do happen, and many variations are instructed in time, and many do not. So the problem happens is when the contractor doesn't get instruction of variations, Okay. As a contract administrator, you look at where is the authorized variation? If there is an authorized variation, we certify payment. So this is where again another area where contractor gets stuck in cash. Okay, so we do need to look at from management aspect of it and see when the variations do happen. There are cases where projects where we went to the client and recommended. So there are plenty of variations where the contractor believes it's variation. It's not been evaluated. A variation instruction form has not been given. So therefore, what do? In such cases, now we do allow all account payments for variations not even instructed. So, but based on the merits. Again, there are certain management aspects involved in taking over certificates when the completion happens. You don't need to wait for all the contractual obligations for the contractor to be completed when the taking over certificate is issued. These can be started much earlier to the substantial completion. Therefore, those obligations of the contractor can be done quickly, and then important thing is you can release retention. And aspects of releasing retention also we have looked at the contract to facilitate two-stage first offer release retention, which means when the as-bills and all the obligations are submitted, he gets the first half of the quarter of the total retention payment, and then the as-bills and all the documentations are approved, he gets a balance of the retention. So these kind of things are able to help the contractor in terms of management, and it's all to do with cash flow, and it helps cash flow. So I have touched on various clauses and how to implement the clauses and what notices to write and what delays and extension. However, I think you will find it interesting and just more of the management aspect. Thank you very much.
Thank you, Mr. Sampath. Next, I'm inviting Dr. Sridhar Gothe to talk about change in variation aspects in contract from his own experience. Thank you.
Hello, I'm Dr. Sridhar Gothe. And mostly I'm these days involved in teaching and training as a subject contract management, including this Manipal. And also authored a book. I'll share the details at the end. I'll be teaching this both ways. 20 years I worked in government as Mr. Kavi and 15 years in private. I teach contractors and department both how to frame a claim and how to defend a claim. Because it is a TTR shuttle game, I know the game both sides. Sorry. Yeah, today's my topic is on deviations, variations, and extra items. Actually, these are the terms synonymically we use in practice, but there is a subtle difference. Variation is a term mostly we use for change in scope. Deviation is for item rate tenders when there is a quantity change, right? Extra item is beyond the scope. Extra item substituted is partly item is substituted, but if the part isn't expressly understood, what are all these terms in the definitions that will prevail? Otherwise, these are the general industry practices. The last line is important. Practically, there is no project that gets completed within contracted scope. We may be having projects in a typical Indian context ahead of completion. DMR Sridhar has completed a work, the client. But practically, no work can be completed unless there is a scope reduction drastically. 80% of work contract closed within the BOQ contract completed. Otherwise, generally, however you do methodical planning, systematic planning, most of the investigations take time. There are bound to be deviations or variations in scope because there will be so many reasons. Despite proper care, good planning, elaborate investigations, there are bound to be variations. We see in a contract few important clauses like dispute resolution clause, jurisdiction. Likewise, in this, whether the contract is a change in law permitted taxation, so many, but variation is one of the most important classes, obviously. And what is the purpose of variation clause? Without a variation clause, an employer cannot contractually order a variation. If
a variation clause is there that gives authority for the owner or engineer to order the variations. And that variation clause is also advantageous to the contractor. Why? Because that provides an agreed mechanism. If there is a variation, the employer may only pay some amount, but beforehand there is an agreed mechanism. So it is advantageous for both the parties. And in FIDIC model contract, I'm not going to deal in detail. Clause 13 deals sufficiently and elaborately with variation. 13.2 is a specific clause on valuation engineering. A contract can propose a valuation as a variation and save the cost. Engineer can determine. Right? There are some cost of variations, uncertainty in subsoil. That's why in the CPWD, 100% of variation is allowed for, deviation is allowed for foundation quantities because of uncertainty in foundations. Variations in preliminary design, changes in owner's requirements, additional scope of work, ineffective planning, improper surveys. These are some of the reasons for variations. And when you see the different types of contracts, in item rate contracts, the variation will come mainly because of the item trade is built in BOQ item. There may be certain small job that may not be given in that BOQ item trade, or there can be certain something may be included as a scope of work in technical specification. Your BOQ may not say that. Employer will argue that that is included in specifications, but one will see the hierarchy of the documents, whether item rate, item nomenclature produced or technical specification. These are the question of interpretation of the contract, right? So when there is a variation, generally contract is interpreted with respect to technical specifications, codes, manuals, tender drawings, or so many things, and that depends upon the type of contract. Generally, in EPC contracts, there is a contentious issues called quantum merit claims. Of course, it is agreed that there is a variation out of scope, right? But what is a payment? So that is quantum merit is what? Quantum is disputed. Merit is, there is a Latin word, right? And in EPC, most of the variation claims will occur. Why? Because in item rate, it is a most stated again. Item nomenclature may be the your scope of work, but in EPC, they will be saying a detailed scope of work is given. Employers' requirements are given, some design standards, design basis reports are given, tender drawings are given, some alignment is given. So, based on the data, the scope of work is interpreted. If there is an extra, that is a question again, a point to be deliberated, right? A lot of disputes will come whether this is included in scope of work or out of scope of work, mostly in EPC contracts, right? So, these are some of the important points on variations. Extra items for rectifications and incidental jobs, which are incidental to main work, they cannot be termed as a variations for payment. And only usually authorized variations ordered are considered approved, because unauthorized variations. So when there is a variation, some of the conditions like FIDIC says that within 28 days you have to inform the owner that there is a variation. Only engineer will order a variation, then only you can execute that variation, which are called authorized and approved variations, which are only payable, right? There might be a time, suppose in contract you say within 28 days of occurrence of extra item or say variation, you have to inform the owner. Please scrupulously follow them, right? Unless there may be a condition barring that such variations in disputed or cannot be referred for arbitration, you may be having a trouble, right? And oral instruction should be confirmed in written. Employee may come to the site and say something. You have to inform that you inform orally, right? I am going to execute this. Please approve. Right? These are some of the points. Power of employer to order variations cannot be limitless. You cannot order a variation from irresistible and purposeless. There may be a small road incidental to building, but you cannot make it road, right? Approach road, right? It should not be purposeless and it should not be limitless. That is a question of law. And mostly extra time is allowed. CPWD also says proportionately you will get the extra time for the extra work. But in certain circumstances, it need not be proportional also, because the way of work you are doing is you can plead, right? It need not be proportional always. That depends upon the situation. I authored a book on infrastructure contract management. Second edition recently released. It is available in Amazon or ACL House online stores also. Again, I opened a YouTube channel having a video lessons on contract management that you can just see. One of the lessons are there on contract management topics.
So this is all about me. Thank you.
Thank you, Dr. Mothe. May I next invite Nitya Bansal to talk about technology in contract administration and disputes.
Good afternoon, everybody. So, please excuse me, my presentation doesn't have an introduction of me, so I'll quickly introduce myself. I'm Nitya Bansal. I am the founder of ADRAS, which literally stands for ADR as a service, and it's a advanced case management platform which allows for collaborative arbitration. When I was invited here by Dr. Venkat, he told me to present on technology in contract management and arbitration. But since we are not yet into contract administration, so LR sir came to my rescue, and I think he's pretty much covered everything about technology in contract administration. So I'll still just skim through. But before anything I say, since the topic is technology, I want to make my own disclaimers because I am, although I'm working in technology and arbitration, I am very careful about these three concerns: data security, data privacy, digital divide, because we should always be mindful that we are in a country where there's a lot of inequalities. There's people who still don't have access, they're not even literate, and they may not, the more we employ technology, we may be kind of dividing them or excluding them. And of course, there's a loss of human touch. So since LR sir already spoke about a lot of AI-based technologies that the L&T is already employing in their organization, I'm going to start from there, which is actually the end, because currently it's L&T. I think most of the other organizations will get there, if not now. Like Sir said, they are currently employing both their in-house built technologies, but also some that are from outside. But most of them will be developing, and many organizations will be getting there. But the question is, so let's see what are these technologies. I think again, Sir covered all the AI-based applications in project management. I'm going to once again quickly brief that I've divided the kinds of technology in these five, which is large language modules and generative AI, which has recently been a buzzword. Then there's VR, virtual reality, and metaverse. There's of course analytics, both rule-based and AI-based. There's Web3 and blockchain technologies, and there's the regular automation. So the various use cases of all these in project management could include contract drafting, generating project plans, schedules, designs, layouts, etc. I will not actually go into the use cases of these technologies in project management, but let me limit myself to the use cases in dispute management. So generative AI and LLM is and can be used in drafting of pleadings and awards, assisting in drafting awards, conversational AI and chatbots for grievance redressal, real-time transcriptions and translations, which are increasingly being used. Even the courts are employing them. One of the use cases of metaverse and VR has been remote hearings. I'm not sure how efficient that is. In analytics, yes, there's document analysis and e-bundling, arbitrator appointments. Law firms can use analytics to appoint arbitrators that suit their kind of claim. There's predictive analytics, there's decision support systems, which even the government of India has somewhere mentioned in one of their e-codes document or visionary document. Use of Web3 and blockchain can come in the form of non-fungible records and self-enforcing awards. And automation is regular claim filing, communication, service of documents, etc. Now, since we are all talking about all these advanced technologies, what is the common thread? How do we get to develop all these technologies? It's all of these technologies are somewhere or the other reliant on data. So what do we need to develop technologies that will be applicable universally, or at least, maybe in a particular context, it should be applicable universally. We need relevant, reliable, and wholesome data. Now, for that, these contract management, project information management, and case management softwares, they come in handy. However, in most of the cases, the contract management or the case management softwares, they actually facilitate collaboration between the team members, right? So suppose the head of the organization is able to monitor the work of their, say, the different number of partners, different councils, different managers, and the managers are further able to monitor and track the work of their subordinates. So this is how collaboration in these softwares usually works. So these are internal contract management or case management softwares, even project information management. The problems is, of course, they cater to single stakeholders. They manage only the information and not the processes. They are dependent a lot on human interface because every organization is maintaining their own information systems and they're all entering data repeatedly. The records may differ, and then the question of whose data records are more reliable. So, what has come up, and I think LR sir also mentioned, and I think more and more people are moving towards collaborative softwares, which are collaborative contract management, collaborative project implementation softwares. It could be collaborative case management as well. Why do we need collaborative softwares? Firstly, the data in these softwares will be undisputed because it will be uniform throughout all stakeholders in a particular transaction. Secondly, yes, the data entry part will be, the efforts in data entry will be reduced because one party uploads the data and it's accessible to the others, and so on. It can easily facilitate automation. It can, yes, result in better analytics and AI-based assistive solutions. I'll give you some, I will not be naming softwares, but yeah, basically how collaborative contract management, when I say contract management, I'm talking about softwares which are helping in negotiating and reaching a contract. So these would have basically dashboards or logins for both or the number of parties to a contract, and it will automatically help in contract negotiation, drafting. So basically it will collaboratively help in negotiation, drafting, approval, execution, signing, contract compliance, etc. In a project implementation, a collaborative project would somewhat look like this. There will be collaboration at all these levels. And this is a BIM workflow model. I will now quickly just touch upon what we do. We are Adras. We offer a platform which is a collaborative arbitration where the collaboration is at all these levels. So we have logins for arbitration institutions, arbitrators, contractors, employers, and their respective legal representatives. We can, of course, add expert witnesses as a login. And not just one logins, we also help in internal risk management because at each level, we will also give them the right to create sub-logins for their own subordinates. Yeah, so that's about it. Due to dearth of time, I will not. Thank you.
Thank you, Nitya. We have now the next speaker, Mr. Pradeep Mochavana. He's going to talk about contract administration.
Yes. Good afternoon, everyone. I'm given the honest task of covering the last subject before we go for lunch. I'm trying to make it as efficient as possible, and mostly the points that I'm covering, everybody knows every information. So let me try to be efficient. Everybody knows everything. That is what we see when we go to meet customers, whether it is a contractor or a lawyer. He comes up with a problem and then he says, I already have a solution. But then he comes and keeps asking us, how do we do it, what do we do it, what value we can add. So these are some of the issues that we face. But then when we look at the foundational solutions that we can probably provide are three in number, and I'll be talking about two of them. One is your integrated PMIS, and maybe a little bit on the baseline checking. Integrated project management information system basically has become a requirement in most of the construction contract nowadays, and we see most of the employers specifying in the contract document for the contractor to implement PMIS as soon as the contract is awarded. And then the contractor goes on developing the schedules, the progress, budget, risk, and resources during the planning stage. And every month he keeps on giving this updates, whether it is relating to construction or whether it is relating to quality and C, or maybe even the change management, the resource management, and of course the project and schedule are some of the things that we are giving. And all this information needs to be shared to different stakeholders within their organization as well as externally. So he needs to have an integrated approach in developing and providing the requisite information as a dashboard. So since the information required are different for different stakeholders, the necessity of developing different dashboards for different stakeholders comes into place, and then it is basically a mix of all the information that is required in terms of whether it is a scheduled progress or maybe even the construction part, the engineering part, what is happening, and the regular updates, the MIS that is required for the project managers to take a decision and support any mitigation requirements. Basically, we are providing some of the services similar to what is available in the industry, and we are using Range as a platform to provide solutions which covers the entire ambit of the project management as well as the contract management processes, including construction, the contract personnel, managing the contracts, whether it is the engineering personnel, and of course giving the management the requisite information on a dynamic nature, since the solution that we can provide is possible to mobile uploads even from the project sites. Basically, this is a snapshot of some of the dashboards that we have developed for one of our major client, high-speed rail, and we can do either in tabular form or a graphic form, depending on the needs of the person who is looking at the dashboard. The next point that I would like to discuss is regarding the baseline schedule. These are on the left. You can see I'm showing you just a simple version of what's there. Probably there are 10,000 activities in some of the complex contracts that are online. And then on the right hand side, you have the updates for the programs. What we have seen is the importance of the baseline program in progress monitoring as well as after the contracts are executed, or maybe during the contracts are executed, you will have claims and determination by the engineer for the EOTs. Unfortunately, there are quite a few flaws that we have observed in some of the major contracts baseline programs that we have reviewed so far, and some of them are very basic in nature, and these delay some of the major decisions that are taken, especially related to the EOT claims, and then these lead to arbitrations and things like that. So some of the things that we recommend to overcome these flaws is to look at lessons learned from previous projects, or to have a clear review or a broader review from either a shareholder if it's a joint venture, or maybe from other divisions of the same company. And you can also look at having the checklist based on the industry acceptable guidelines that are published by some of the American associations, whether it's the DCMA. Of course, DCMA is now the Primary Basics program includes the DCMA for the checklist as a part of the basics. last slide I would like to discuss is some of the major causes of disputes. It's common thing that we see across the industry, but these are some of the ones that have a major impact on why we are seeing so much of delays, so much of cost overruns across major projects. So, thank you very much for giving me an opportunity and
Thank you, Pradeep ji. Couple of questions have come up. I'll request Ganesh Kavi sir to quickly address them. They will address them.
Yeah, thank you. Only two questions targeted at me. I will take one. One question from Rahana. I understand the question is that performance guarantee forfeited, did not imposed at that time, contract terminated. Question is that how the arbitrator shall view it. The brief answer is that arbitrators, the issue will come either under section 17 of the NCA under interim measures or as a dispute to be decided in the award. And most probably before that it will go to section 9 in the court, but most of the time when performance guarantee is forfeited, the tribunal will not be there. In one of the cases when I am presiding arbitral measure case, I think this same happened. So section 9 court rejected, in the tribunal we allowed, we gave a relief. It has gone under section 37. But this what we will view, the tribunal will depend on the facts and circumstances. The unconditional bank guarantee, there is a problem. But again, even for an unconditional bank guarantee for forfeiture, the procedure and requirement of forfeiture must be met. If it says some amount is due or likely to be due, if that is not done and it is caught, then it may be questioned. So, and we do not know the final outcome. Second question, and finally, of course, it will be decided on merit. If the termination is valid or not, mostly PBG will be forfeited for termination. And of course, if you go in a larger way, then forfeiture is a penalty under section 74. Loss is to be proved, even if it is mentioned in the contract. So it is not automatic that anything PBG is there, the entire amount can be forfeited just because contract forfeits. Second question is that does time bar provision is valid for EOT claims? I think if you are referring to section 28B, I would not go that far to apply section 28 for make time extension things. Because you understand this time extension provision is a part of reciprocal promises or obligations. So, and it is linked. So, one party contractor has to apply for time, then so then it is also should be seen independent of section 28B as a breach of terms of contract. If contractor does not apply for extension of payment time. But then this is a question subject of interpretation of construction when it should apply. When actually depending on the clause, if time is provided from actually date of occurrence of the delay event or the assessment of delay when this impact is felt, and there are difference on this. And I think I will close with that. Thank you.
Thank you very much. So the session comes to an end. Thank you very much for the panelists and also to the audience. Thank you.
Thanks to Mr. Asif Said and other distinguished panelists. In fact, this particular theme is so very huge that the body of knowledge, you can compare it to a full-fledged movie, but what you just saw was just a glimpse. Perhaps we can delve much more into it in days to come. To do the honors on behalf of the Manipal Academy, may I now request Mr. Rajiv Dwivedi, the well-known advocate and arbitrator, to please come out of the rehearsal to do the honors on behalf of Manipal Academy. May I request the moderator, Mr. Asif Said, to please step forward so that we can honor you and the handwriting. Mr. Asif Said, please. So, ladies and gentlemen, please give them a round of applause for all the anti-police shade.
Thank you, sir. May I request Mr. Ganesh Kavi to please step forward to receive the honors. Thank you, Mr. Ganesh. Mr. Lakshman, requested to please come over to the dais. Thank you, sir. Mr. Sampath Raman, sir. Please step forward. Yeah. Ladies and gentlemen, request you to please give a loud applause to all the distinguished panelists for their erudite views that they have shared.
Thank you.
Thank you, Mr. Rajiv Devadi. Now may I request Mr. Mayank Singh to please step forward. Mr. Mayank Singh, who is an expert in delay analysis from MAHE. Mr. Anurag Krishnan, sir, please step forward to receive the honors. Mr. Anurag Krishnan. Thank you, sir. Mr. Pradeep Mokshulunda. Thank you, sir. Thank you for sharing your views. Let's applaud Mr. Pradeep Mokshulunda.
Turn this side, turn this side.
Ms. Nitya, may I request you please step forward. Thank you, Ms. Nitya, for a very brief but very interesting presentation that you made. Now we have Dr. Sridhar Mote, author of two well-known books, the recent one which has just been released. Dr. Sridhar Mote. Thank you. Thanks, Mr. Mayan Singh Thakur. And we have a very important, but I think this announcement will be liked by all of you. We will endeavor to provide the PPT of all the panelists, subject to their permission. And very shortly, once we have the permission, we'll create a link and share it with all those who are registered with us. Thank you. We break for lunch. The lunch duration is 30 minutes. And we'll again congregate back onto this hall. Lunch is being served in the hall next door. 45 minutes. Yes. Okay. The lunch break is for 45 minutes. Perhaps it will book in the networking as well. Join us all for the lunch, please.
I'll take my phone out.
Thank you very much.
How will you do that? Now it's not coming. No, there.
I'll tell you what to call this.
Huh?
We also welcome Mr. Ronak Desai as the panelist. Yes, Ratan sir, the panel is all yours. Please take.
Good afternoon. This session is very relevant for the industry. This session is very relevant for contract managers, project managers, construction lawyers, as well as arbitrators. What we are going to cover in this session is the aspect of quantification of claims or quantum and quantum analysis, as well as delay and delay analysis. This may sound as very normal thing for me, but in my experience, I can tell you, when it comes to quantification, I have seen parties, both sides in arbitrations, they devote 90% time on the liability side, or the delay side, on the liability side. They give very little attention to the quantum side of the claims. Even if you succeed on liability side, if you have not been able to substantiate your claim, then you tend to be illusion. So therefore, what are the claims in a particular situation? How those claims are to be pleaded? How those claims are to be really substantiated? What are the evidence which are supposed to be brought on record? These are very, very important aspects. Very recently, I was doing one arbitration there. 84 hearings had already taken place. And I was asked to argue on one particular claim which was running into hundreds of crores. When I went through the records, I realized that they get nothing because despite of having a fantastic claim on liability side, they are not able to really substantiate the claim. So this happens very usually. Another important aspect is what are the claims which you can have against the other side? And again, here we lack substantially, I would say, in India. So this is one side of this session which will be covered by some of the panelists. Another side of this aspect would be what is the liability side of it, particularly on the aspect of delay. What is delay and how delay are to be determined? And here comes the problem. And the problem is about primarily because of lack of awareness amongst stakeholders. Here comes the role, if we are talking about delay, here comes the role of delay experts. And I have seen in many mega arbitrations where parties themselves are not aware that here comes the role of delay experts, or this experts. Problem is also on the side of the lawyers. Even the lawyers representing parties are not aware of the role of the delay experts. And then comes the another bigger problem when your arbitration tribunal itself is not aware of the role of delay and disruption experts. There have been occasions where I have myself encountered a situation where arbitrators will say, do you think we don't know how to decide cases? Why should we have somebody, an independent party, to do a delay analysis? So these are some of the aspects, very relevant aspects, which we are going to touch upon today. And for this, first of all, we will start with Mr. Julian Bailey, a very good friend from UK. Julian has not been able to come, but Julian has consented to speak online. Hi, Julian, how are you? Can you hear me? Last year, this time of the year, Julian was in India and we were speaking in many events. Julian, can you hear me?
He is hearing. Only we are not.
He can. Oh, okay. So we will start with Julian's presentation. And Julian is going to talk about notices and time bars. What is this? This is very, very interesting aspect, where in many jurisdictions such as UK and other jurisdictions, if your contract says that you have to raise your claim within 28 days or 57 days, if you do not raise your claim within those 28 or 57, whatever it is, you forfeit your right to raise your claim. So that is one side of it, and then you have other jurisdictions. So Julian is going to talk about all these aspects, and he's also going to touch upon the Indian scenario. So I'm handing over now to Julian. Julian, you can start now.
Thank you very much, Ratan, and hello everyone in Bengaluru. I'm very sorry I can't be with you. I hope you can see my slides.
Yes.
Are they on the screen?
Yes. You need to use the mics on the phones. Yeah.
It should be behind you.
You please respond.
Okay, that's great.
Respond using the mics.
Yes, Julian, we can see your slide.
Perfect. Thank you very much, Ratan. Right, well, it's a real honour for me to be here, albeit virtually. I was looking at the weather today. It is 34 degrees in Bangalore and it's only 8 degrees in London, so there's a bit of a difference there. I hope you're enjoying the heat. Now, speaking of heat in a contractual context, we're going to talk about something which is very important when it comes to making claims, and that is time bar provisions, which we find in many construction and engineering contracts, including most notably the FIDIC form of contract, which I'm going to look at right now. Let's start with some basic. What is a time bar provision? Well, it's a provision in a contract that stipulates that if the contractor is looking to make a claim for an extension of time or for additional payment or for both of those things, then the contractor is required to provide a notice to the employer or to the engineer within a prescribed period of time, failing which the contractor will lose its entitlement. Its claim becomes time barred. And we can see this from this particular clause from the FIDIC 1999 suite on the screen, subclause 20.1. In the first paragraph, it says that the contractor, if it considers itself to be entitled to any extension of time or additional payment under the contract, it has to give notice of that to the engineer. And the notice needs to be given as soon as practicable and not later than 28 days after the contractor became aware, or should have become aware, of the circumstance. That's the contractor's obligation. It has to notify the engineer of the particular circumstance in a timely way, with a maximum of 28 days. And then the subclause specifies the consequence of the contractor not giving notice within that period. And it's very clear. It says, if the contractor fails to give notice of a claim within such a period of 28 days, here comes the consequence. The time for completion shall not be extended, the contractor shall not be entitled to additional payment, and the employer shall be discharged from all liability in connection with the claim. That's a very clear provision, and it has very severe consequences for a contractor making a claim if this clause is applied, because it means the contractor's claim is lost, or maybe it never materialises. Now let's go on to consider, to go to my next slide, some of the arguments that we see in the Middle Eastern region, in the Gulf, and also in India, in relation to time bar clauses, because we hear a lot, there's a lot of chatter that goes on, which I've described as law, L-O-R-E, as in folklore, but there's less law, L-A-W, which is there, about these clauses and their effectiveness. Now, some of the law that we hear, the folklore, if you like, we hear arguments that clauses like this are unenforceable because they represent a shortening of a statutory limitation period. So a statutory limitation period could be 6 years or 3 years, and the effect of the clause, the argument goes, is to reduce that period to 28 days, and that's not permissible. That's one argument that we hear. Other arguments that we hear in the Gulf, and I think also sometimes in India, is that an employer can't rely upon a time bar clause where the contractor is late in giving notice if it suffers no prejudice because of the notice being slightly late. And it could be argued that the employer would not be acting in good faith, or it would be abusing its rights if it were to seek to rely upon the time bar clause where the contractor is late. So we hear these arguments floating around quite a bit, and there's a lot of chatter about it, but there's less case law to do with these time bar clauses. Now, I now want to move on to some developments in that regard, because although historically there haven't been many cases, certainly from the Gulf or from India, new case law and new ideas have come forward, including there's a case that many people will know about from last year on the DIFC Court of Appeal, Panther Real Estate and Modern Executive Systems from May last year. This addresses the time bar issue, but in a fairly narrow way, mainly because of the way the arguments were made before the court. This case was about a block of apartments, which you can see there at the top right of the slide in Al Fajan in Dubai. You can stop renting and buy your dream home for 3,500 dirhams a month, according to the ad. Well, that might be great if you're looking to live in this lovely apartment block, but it wasn't so great for the contractor in this case. What happened? Well, there were quite a few things that happened, but most relevantly was this. The contract was a Red Book form, the 1999 form. The project ran late, and the contractor was delayed by almost 1 year. It said it was entitled to extensions of time because of the various delays, and the employer rejected the contractor's claim, saying, no, we're not entitled to an EAT. You are responsible for the delay. But there's a further aspect, which is where the time bar clause comes in. The employer said, well, even if you were entitled to an extension of time for 306 days or whatever it was, you were late in giving notice of your extension of time claims. And therefore, under subclause 20.1, those claims are time barred, and the employer would therefore be entitled to claim delay damages for the contractor's delay. That's even if the contractor was not culpably in delay. The argument came before the DIFC Court of Appeal, and the employer's argument was actually upheld in this regard. The court applied the terms of subclause 20.1 and said that looking at other possibilities, other arguments, such as good faith, the court seemed to discount that being a reason why the employer could not rely upon the clause. Quote from the judgment here, which I think provides a reasonable summary of the court's approach. And the court said the contractor was a willing party to a contract which included the 28-day notice requirement in subclause 20.1, etc. Those provisions are clear in their words and in their effect. They admit no scope for the postulated implied term or obligation of good faith. There is no reason why the overriding principle of pacta sunt servanda should be circumscribed in this way. Pacta sunt servanda meaning essentially that the parties who enter into a contract will be bound by their terms. So this is a very interesting case, I think, because it shows that here is a court in a part of the world where time bar arguments are often made, and the clause is upheld by the particular court. But I pose the question you see on this next slide about whether this case, the Panther case, represents the last word on time bar clauses in the Middle East. And I suggest probably not. I think that there are more arguments that could be made that weren't actually made in this particular case, such as about abuse of rights, good faith principles more generally. I think there's more to be discussed there, but this will be an influential decision because of the standing of this excellent court in Dubai. But we should understand this is not a decision which is binding anywhere apart from within the DIFC region. So I therefore suggested that time bar arguments such as the ones that were put forward in this case are still on the prowl like a panther. Now let's go from the Gulf to where we are right now, in India. So I think India has a very interesting time bar story to tell, and that story is still ongoing, I suggest. When people in India talk about time bars under construction contracts, the first and perhaps only provision of the law that they go to is Section 28 of the Indian Contracts Act. And this is a lengthy section. I haven't set out the full part of it, but this is the relevant part here. And it's referring to agreements in restraint of legal proceedings. And it says every agreement by which any party thereto is restricted absolutely for enforcing his rights under and in respect of any contract by the usual legal proceedings in tribunals, or which limits the time within which he may enforce his rights, or which B extinguishes the rights of any party thereto, or discharges their party from liability, etc., is void. Now, this provision, in essence, therefore, says that contractual provisions which purport to restrict a statutory limitation period are void. And it is sometimes said that this provision cuts across time clauses, because what these clauses do is, in effect, shorten a limitation period from, say, 3 years to 28 days. And that is the argument that's put forward about these provisions. Now, that argument proceeds on the basis that what a time bar clause is doing is taking an existing right that a contractor has and then extinguishing that right because the contractor has not claimed its extension of time or compensation within the relevant period, say 28 days under the FIG form. That's how the argument proceeds. But there's another point of view, which I think is, if I may say, very well expressed by Gracious Timothy in an article he wrote for the RBA's Journal of Construction Law International. This is from 2021. And Gracious, in this great article, examines how time bar provisions might work in the Indian legal environment, because, as he notes, what these clauses do is that they precondition a right coming into existence. So the right to an extension of time or to claim more money will only arise if a notice is of claiming the right from the engineer, for example, is given within the 28-day period. So this is the other way of looking at these provisions. They're not taking away an existing right. These clauses precondition the existence of contractors' right to more time, more money upon giving timely notice. So there are some very interesting arguments floating around. I think we're still on a bit of a journey in relation to notices and time bar provisions. These are fundamentally important provisions in construction contracts when it comes to making claims and also for employers defending claims. So there's a bit more for us to discuss, but that will be probably for another time or another session. So thank you very much for listening to me.
Thank you, Julie. Thank you for the fantastic presentation. It was a very good comparative analysis between common law jurisdiction, civil law jurisdiction, and Indian scenario because of Section 28 of Contract Act. If there is any question for Julian, Julian will be happy to take that. Any question in the audience? No. So Julian, your presentation was so well received that nobody was left with any confusion and question. Thank you very much. Julian is senior partner of Jones Day. Julian is author of a very celebrated book on construction law, which runs into 3 volumes. And that's it. Thank you very much, Julian. Thank you very much. Ladies and gentlemen, now our next speaker, again, will be joining virtually, is Mr. Sundra Raju, who doesn't need any introduction in Southeast Asia at least. Sundra, again, old friend, and Sundra is director of AIEC. Sundra is the most popular construction arbitrator in this region. In fact, there is one award which his tribunal had written. It was an ICC award seated in Paris. One Indian contractor had done a work in Ethiopia, and I'm doing one litigation of this in Hyderabad. So now, Mr. Raju, Sundara Raju is going to speak on role of experts in construction arbitration, and he's going to give you the arbitrator's perspective. On this particular aspect, role of experts in construction arbitration, we have two speakers. One, Mr. Sundara Raju is going to give you arbitrator's perspective, and Mr. John Tubo, on my right hand side, will be giving the expert perspective. So let us hear Mr. Sundara Raju on this arbitrator's perspective on role of experts in construction arbitration. Over to you, Sundara.
Thank you, Ratan. It's a great pleasure. Thank you for having me. It is evening in Malaysia now, so I think it's a bit earlier for you all. I'm going to talk about the role of expert witness in construction arbitration. So starting off with what is an expert witness, I think the best way is the comparison with the court. And the very old case of Davy Magistrate of Edinburgh said that the role of the expert witness in court is to furnish the judge, therefore even the arbitral tribunal, with the necessary scientific criteria for testing the accuracy of their conclusion, so as to enable the arbitrator or the tribunal to form their own independent judgment from the application of criteria to the facts proved in the evidence. So essentially, it is actually opinion based on facts. So if we really consider that in an arbitration, normally arbitrations, there are different types of arbitrations, but I'll rather now go to the type of experts that we will have. And the category of experts, they basically, I mean, from my experience, two types of experts. One that comes from the parties, the other one that the tribunal itself appoints. The latter way is less frequent, although it has been happening, but it is generally that the parties would rely on their experts as trying to provide an opinion on specific issues and facts that have risen in the arbitration, and they will choose the party appointed expert and submit it to the tribunal for approval. And they will also, the way I normally do it, if you have pleadings, I will say the expert where in the pleadings, what kind of evidence that the expert is going to cover, and then restrict that the coverage to only that part of the pleadings. So I think again, there could be one expert, there could be two experts. It depends on what their expertise is. Sometimes let's say soil conditions, they will have a technical expert specializing in soil conditions. Whereas, for example, quantum, they may look at other kind of experts. The other method of appointing experts is tribunal-appointed experts, and there have been situations where the tribunal, in fact, if you look at the UNCITRAL arbitration rules, it provides for the tribunal to appoint experts. So I think, but normally the tribunal, when it appoints experts, it will consult the parties. And I think that is the first thing. So now I want to go, what is the difference between construction arbitration and commercial arbitration, the need of experts in construction arbitration? So the main thing is that there are three types of why sometimes construction arbitration is a bit different from commercial arbitration. First thing is sometimes in general commercial arbitration, parties are able to estimate their loss beforehand to some extent, and the contract clauses will actually provide for how the damages are to be calculated. And there could even be an estimated amount. It's not necessarily true all the time, but sometimes there is. But in a construction contract, the issues are complex. It ranges over many things from program to cost, for reasons of delay, technical issues, experiments, sometimes faulty equipment, defects in design, many issues. So the compensation, to determine the quantum of damage or compensation, the arbitral tribunal will sometimes, or the parties themselves will adduce expert evidence to show the quantum of damages. The second thing is that I think when I discussed that about the quantum of damages, you will realize that the nature of construction itself is complex. It involves multiple parties. We know in a construction contract there is main contractor, employer, design team, different types of specialist contractors, and also the second is the duration of the construction contract itself may be over many years. So this produces a lot of data, a lot of information, and this needs to be analyzed, to be actually recorded and analyzed. And it may not be the case in the case of commercial arbitrations, which may be an interpretation of a clause in an agreement. So construction arbitrations will involve violations of specification, workmanship, sometimes materials. So it may also go to payment defaults. So it is a bit complex. The other thing I did mention, there are multiple stakeholders. Many people are involved, from the consultants to the contractors to the employer, and they take different positions in the construction contract. Now, the type of construction experts is also divided. In fact, when you do a construction arbitration, then you will realize that there are different kinds of experts now specializing. Of course, the first thing, as I mentioned earlier, technical or scientific experts. So they are normally engineers, from my experience, or specialists. They are, let's say, geotechnical engineers, sometimes geologists. They may give evidence, opinion evidence as relating to soil conditions. Then you have the next type of expert, which is what we normally see. We normally see delay experts. A delay expert is an investigator. He actually investigates and tries to understand the event and the delay, and what was there a changing in the planning that caused the delay. So, and looks back normally in an ex post facto, after the event, tries to identify what is the root cause of the delay. So I think that is it is quite interesting, and there are many ways that this kind of opinion will come through by delay experts. They may have, for example, an impacted on plant analysis. They may have a retrospective view of the longest path analysis, or they may even look at S-plan and S-built analysis, and then they will look at a deducted S-plan analysis, and then sometimes they look at time impact analysis. So it depends what method they use. Then I did talk about quantum. One of the important things in construction arbitration is you really sometimes need an expert to advise you what is the quantum that needs to be, like variations. How do you get to calculate the variation, to value the claims, and actually you need someone perhaps because there could be a complaint that there was under certification and that the valuation was not done properly. So you may need an expert. The quantum experts will come in to establish what is the actual value, and then they also show the material causality. Then we have the last type of expert, which is quite rare. I mean, in construction contracts, but I think it's more in international, public international law, legal experts, where they actually venture an interpretation of the law or interpretation of the particular contractual arrangement. So I think now going to the role of the expert witness in construction contracts is that I think first thing you need the expert is required to clarify and summarize the evidence, which may be difficult to digest for the tribunal. So the tribunal is able to get an overview. It's the most important people where the expert evidence is directed at is the tribunal. And then they should use the expert knowledge to interpret the data in a sensible way. Sometimes they do it in, I've seen in my own arbitration, they have gone off the rail. But of course, we actually evaluate how useful the evidence is, and then sometimes it has to be complete. They also sometimes have to identify gaps and missing information. Sometimes they have to make assumptions and whether it's reasonable assumptions, and then they will actually try to identify the missing data and try to provide professional opinion on zones that are in between gray zones. And finally, they may also derive conclusions. They may ask questions and say, okay, this is the answer that I should give and why it should be arrived in such way. And then they have to, of course, be reasonable in their conclusions, which I've seen many experts have not. Sometimes they become hired guns. And then, of course, at the end of it, it is what is the value of that expert evidence to help the tribunal to reach its decision. So I think that is the one. And there is a case that I think everyone should read, which I read many years ago in the 1990s, the Icarian Refer, which is I think sets out the duties of expert witness. So I think if you have a chance to look at that, and then the common areas that expert evidence is applied on is construction defects. I better go a bit faster, and then delay, and then payments. There are cases. You can have the slides. I can explain to you all. And then I also realized that Doug Jones, one of my favorite arbitrators in the world, he said that the landscape of using expert witnesses have undergone a profound transformation. And it's very interesting that I give you an example. When you have two experts from the parties and they actually deal only with their issue, the arbitral tribunal will actually force or direct the experts to also deal with the others' issues that have been raised, so that you have a full view of all the conclusions that you can possibly get from the facts. Thank you, Ratan. And I don't know whether I overshot the time. I was a bit nervous. Thank you.
Thank you, Sundara. It was a fantastic presentation, I must say. Any questions from the audience?
They're sleeping, looks like.
No. So there is no question. I have two questions, Sundara, for you. You said in your presentation that you would want the experts to stick to the pleadings, and you would like to see whether their report goes beyond the pleadings. What happens when the delay is identified by experts, or sometimes both the experts, are totally different from the delays identified and pleaded by both sides in their pleadings? And I'll tell you, there is an example where John was the delay expert from my side. both the experts from both sides identified delays which were not at all cleared by both the parties. So how will you look at it?
The first thing I will ask them, why this happened? Please tell me, this is what is pleaded and what are you telling us about this, which is completely different from the pleadings. Okay, and then they will give you a reason, but I think the most important thing, of course, like all matters, you are bound by your pleadings or your case stated or statement of claim, statement of defense and counterclaim. That actually sets the boundaries, and within that the issues will be identified that require expert evidence. So the expert evidence will be related to those portions. So when you look at those portions, and if you see the expert evidence is moving somewhere else, then it is not very useful, is it, for the tribunal to decide how to use the evidence which has no relationship with the issues at hand. I think this is the point that Ratan, I think you're making, isn't it?
Sundar, difficulty is this. You were talking about an ideal situation where parties could have really identified the delays which were really critical delays, falling on the critical path, proper examination analysis done. But generally what happens, particularly in India, is invariably parties would really themselves not know what were those events which were really critical in nature and which had really caused the delay. So what they came out with is just a general understanding without any analysis, and that's why this problem. One more question, Sundra. I don't want to let you go without answering another question.
I just respond to that, Ratan. We call it ships passing in the middle of the night, each other. I mean, there's a balance that we have in the arbitral tribunal. In fact, I remember sitting in one tribunal and we were looking at the expert evidence. Both of them were not answering the question. And I mean, we had to deal with it. Of course, whenever the arbitral tribunal is faced with such a situation, it will actually deal with the evidence and say it's not very useful, why it's not very useful. Or if it's useful, why it is useful. Because at the end of it, the final decision whether to accept the expert evidence or not is dependent on the arbitral tribunal. So I think to just respond to that, yes, sorry, Ratan, thank you.
There's one more question. You have a scenario where you have two delay experts cited before you. One is straightforward, who has got experience, who is really an expert, who knows his work. He has been broadly, if you see the report, you find that his report seems to be broadly on the lines. He has followed the delayed methods of analysis. He has followed AAC, he has followed SCM, and so on and so on. On the other hand, you have an expert who is not trustworthy to the tribunal. Now, will you as an arbitrator get into the merits of the reports of both sides, or you will be happy to go by one expert who is otherwise straightforward, very straightforward to the tribunal, who is trustworthy, and broadly you think that he has followed the method?
I'm trying to understand your question because I lost you in parts. But nevertheless, let me try to, as I understand it, is that you have one expert who's very well known, very experienced, very on. Then you have another expert who is not so experienced, but nevertheless, I think the first thing the tribunal does is when it's asked to actually given an expert, it will look whether the expert is qualified to do it. But once you accept the expert, the person as a qualified person, then you have to look at the opinion that he provides, rather than trying to say that he's not very clever, he's not very experienced. I think that does not come into the play at all, because once you accept that, in fact, I think the first step is to actually say, look, I don't think so, this person is an expert. So one of the things that will happen is that they will normally put a curriculum vitae. A curriculum vitae to say why this person is an expert. The person is an expert because the person has training, the person has experience, and the person has given evidence on such matters and is acknowledged to be an expert in that area. So once you accept the expert, in the tribunal. So we just look at the evidence as it is presented. It's an opinion. Of course, I think grey hair does matter in many things, but it is not necessarily the determining thing, except because only the evidence that is useful, relevant, in the sense that it explains, it must have some explanatory power to make sure that you can decide in the correct way. Expert evidence is actually no substitute to factual evidence. Factual evidence, in fact, I think many of the tribunals are experts in their own field, but we are not allowed to actually take secret evidence from ourselves. If we do actually venture an opinion that we have to actually put it to the parties. That is a very, very fundamental requirement. Thank you, Ratan.
Thank you, Sundara. As usual, you were excellent, very eloquent, and you have really covered the aspect from the arbitrator's perspective. Thank you very much, Sundara. Thank you. Thank you for being with us. Now, ladies and gentlemen, we have John Prudhoe. He'll give experts' perspective on the role of experts in construction arbitration. John Prudhoe is Senior Managing Director of Ancora, based out of Singapore, and he is one of the most experienced delay and quantum expert in this part of world. And so, over to John.
Yes.
So we'll get your presentation.
So I'm very, very happy to be here. I love being in India. The last time I was in Bengaluru was 12 years ago, and I remember driving from the airport to the city and seeing all this viaduct construction going on. And then the other day when I was driving into the city, I see all this viaduct construction going on. It seems nothing changes. Fortunately, it wasn't the same viaduct, otherwise I think the delay analysis would have been quite long. Professor Doug Jones has been mentioned by Sundra. I've been in front of him a few times. Rata knows him very well. He's very sort of keen on experts, and he categorises experts into two types. One, the subject matter expert, and two, the delay and quantum experts. The latter being tend to be more experienced in giving cross-examination evidence. Subject matter experts tend not to appear that often because their subject is so specialised. I'm going to be talking today from my experience as a delay and quantum expert. Okay, from an expert's perspective, there are two key attributes that an expert witness needs to bear in mind. The first is that their opinion has to be independent. They are not a hired gun. Their overriding duty is the other one to the tribunal. It's not to the party that appointed them. So those are absolutely key, and any expert who does not sort of comply with those key points will risk their evidence being discounted by the tribunal and discredited by the other side's expert. And if any party appoints such an expert as essentially a hired gun, then they're at risk of losing already. Tony Bingham is a barrister in the UK who writes an article in Building magazine pretty regularly. And he said something 26 years ago in 1998 that I remember, and I've still got the article. And he said, do not become confused by the expert role, but do recognise that the expert has been the target for change. The gun-slinging, rooting, tooting cowboy has gone, but rooting is still in. So what he meant by that is that whilst experts are certainly part of the dispute team, but they must give evidence that is objective, independent, impartial, and complete. So, in my experience though, the hired gun is not gone at all. I come across many hired guns. In fact, I'm dealing with one at the moment on a big case. And so, unfortunately, the party-appointed expert does get a bad reputation sometimes. because of this hired gun mentality, trying to help too hard the tribunal that appoints that person. Anyway, what does an independent expert mean for the expert? It means that I, as the expert, must review the issues and give my professional opinion, not my client's opinion, but my opinion on the issues that I'm instructed to deal with. Before proceedings commence, formal proceedings commence, clients, contractors will have prepared claims. They might have got a claims consultant to help them with the preparation of those claims. Those claims will be partisan. The quantum of the claims are nearly always exaggerated in counts, and if there's a delay case, then the delay analysis will be manipulated based on selection of methodology of delay analysis or selection of facts. It's just the way life is. And similarly, the defendant or the respondent dealing with the claims and counter claims will be similarly partisan. So as an expert witness, there's a need to review all the claims, to analyse them, and to independently verify what actually happened. In respect of quantum, the quantum of claims are typically delay costs, disruption costs, and disputed valuations and variations. And the expert needs specific experience of dealing with those. Disruption claims are common on many projects, but they are particularly difficult to deal with because they span both time and money types of issues. And many construction experts just don't have the expertise to be able to deal with them. And therefore, what tends to happen is in disruption claims, they often become global claims instead of carrying out a proper investigation as to whether or not, in fact, the work was disrupted, by what, and whether any additional costs were incurred. I'm dealing with a major disruption claim at the moment on the case. In respect of delay, the quantum of a delay case is obviously driven to a large extent by the number of days of delay that are compensable. And this is where things can get a bit tricky. The delay expert needs to assess what activities were delayed, for how long, whether they were on a critical path, what caused the delay, and what caused the delay. For example, a simple example, did a blocked access road that's being claimed to cause the delay, did it really cause the delay for the period that is said, or did the contractor not even need that access road for the period in question? Sandra has mentioned various delay analysis methodologies, which I'm very impressed with, and I think Mayank's going to discuss those a bit more. But some of those are only relevant when a project is ongoing, and they need to be prospective, or at least partially prospective, because the job's not complete. And therefore they use the program logic to project forward when completion might occur. And in many cases, in my experience, that logic is flawed, and therefore the results of the analysis is not going to be reliable. However, there is no choice when the job's ongoing. But in arbitration, the projects are often or usually completed well before the arbitration, and then we can look back at what actually happened. And that's what tribunals are interested in, what actually happened. They're not interested in black box type analysis. And those analyses tend to be, well, they are retrospective types of analyses, and one method that's very common in arbitration is the as-planned versus as-built windows analysis. This is a far better method in arbitration because of its simplicity, the fact that it sort of deals with differences from the planned intention, and it's a visual methodology with no manipulation. Nevertheless, on a large project, there might be hundreds of thousands of activities carried out by several different parties, and so the analysis can still be complex. And this is where an experienced delay expert comes into his own. He will not only need to know how to carry out the delay analysis, but also to explain it in a very clear, succinct way in a report, presenting the analysis simply, clearly, and setting out the opinions on the basis of it. He also needs to be, or she needs to be, experienced in the type of project, whether it be a tunnel, a road, a rail, or a power project. All of those types of projects I've been involved in India. I come across experts whose forte it is in forensic analysis, but they're not experienced in construction methods and sequences. And that's so important if you're an expert witness in delay. And if you don't have that experience, then you're at risk of coming up with the wrong conclusions. Tribunal members like Ratan Singh and Sundaraju, whom I've worked with before, are very familiar with construction disputes and the sorts of issues that arise in delay and quantum. But some tribunal members are not so experienced, and in that scenario, being an experienced expert will enable to get key points over simply and clearly. I try very hard to do that, and having interrogated the project records and analysed the delays, it's necessary to convince the tribunal. And this can be aided with visual pictures. And I'm just going to show you a couple of pictures, if I can do this. Did you knock it on one slide? Somebody? Yeah, okay, good. Thank you. So, visual pictures I'm talking about and how that can really help the tribunal. The picture on the screen is where I'm trying to link cause and effect. And I would say the weakest thing about any construction claim is the lack of causation. Contractor says, you did this, you did that, you did the other, and as a result, it's cost me a fortune, here's the bill. But where is the link? And that's where contractors' claims, subcontractors' claims fall down, and clients' counterclaims fall down. And so in this chart, what I'm trying to do is link the cause and effect. In the upper half of the chart, which is dealing with the progress on 56 kilometres of road, the darker the green bars and the higher the bars are, the more progress was achieved. And where there's just white or very light green, less progress achieved. In the low half, what I'm trying to do is to show what the cause of that was at this particular point in time. Most of the cause was caused by the lack of access, but there were other things as well. Can you move on to the next slide? This is another sort of cause and effect, but this time it's trying to deal with disruptions as well as delay. The green bar is the planned duration, the red bar is the actual duration, and the red bar combines man-hours. And that's why you see these pulses of man-hours, and the sort of longer the bars, the more man-hours were carried out. And you can see just looking at that, there was disruption, and the triangles below, which are all cross-referenced in the schedules, are the cause of what happened here. And this is a rail project, and it's all about access to the rail. So there's a couple of examples, I'm not going to do more, of how visual aids can help, and certainly dealing with sort of cause and effect, which is so important in dealing with claims. The other thing about experts is that their reports must not be written by lawyers or by the client. They must produce their own reports. And the skill of a good expert doesn't just relate to what you produce in a report, in your first report, or what they say in the hearing, but it's about what they say in their reply report about the other expert's opinion. And again, quoting from Tony Biggin, what he said was, "A gem of an expert will assist the real advocate, telling him which parts of the other side's evidence are doubtful, wrong, or just daft." And I have to say that I found mistakes in my opposing expert reports many times. One such case that's really memorable for me, because it was so extreme, was that in a quantum case, when I looked at it, the other side's case changed from a positive figure to a negative figure, and as a result, the matter settled. So in conclusion, because I've run out of time, I'm going to sort of support what Sundaraju just said there. The most authoritative case on the role of the expert witness is the Icarian reefer, back in 1993, George Cresswell. It was about a ship that ran aground off the coast of Africa. And in that, the judge set out what he expects from a proper expert. And I recommend that anyone who wants to be an expert read that judgment. It's very good. Thank you very much.
Thank you, John, for a fantastic presentation and reminding the experts how to be an expert. So with this, now I move on to Another expert in the panel, Mr. Manipal Singh Thakur from MAHE. He is very well recognized expert, and he's going to talk about quantum analysis, the practice in gap analysis. Over to you, Mayank.
So very good afternoon. And I know it's a session post lunch, but I'll try to keep everyone awake for my time. Have the slide, please. So I will slightly touch on delay analysis methodologies, and then I'll move to what is the general practice in quantum analysis and what are the gaps or what are the challenges faced in quantum analysis. Now, two of the dignitaries before me have actually explained what should an expert get into and what you should not get into. So I will try not to get into the areas which are beyond my expertise. And I will agree to John to most of his address. So getting to delay analysis. So what is a delay analysis? So delay analysis is analyzing the delays that has been encountered by the parties during the course of the project, who caused the delays, and what extent of delay. So what is the quantum of delay and who is responsible for it. So Society of Construction Law Delay and Disruption Protocol, which is generally called as SCL protocol, provides with 6 methodologies. So these are the 6 methodologies which are used by various delay analysts to come to a conclusion of what I just said. So basically, 3 are prospective technologies, methodologies, 3 are retrospective. So as John said, the prospective methodologies may be used when the project is ongoing and to determine what is the theoretical end date of a project, or what is the effect of various causes that has happened on the baseline program or the various programs or program updates. So extensively programs are involved. The second is effect and cause, that is retrospective. In this case, we will see what is the effect plus first. So what effect has taken place, what delay we see into the project, and then we go back and try to find the causation. What caused this delay and who is responsible? So as a delay analyst, one has to take a decision which of these methodologies to use. So what are the factors which basically are in front of a delay analyst which helps him to decide which one of these to use? The most important factor is the documents. What documents does he have? So basically, impacted as planned or time impact analysis basically needs the baseline program where you can model the delays and give a prospective result. Whereas when we are talking about collapse as built methodology, you need to have a meticulous as built program, and please understand, and 100% updated program is not an as built program, and it is really very difficult to find that, at least in India. Whereas time slice window analysis is again a method where program becomes very handy, and it actually is a retrospective analysis. You see what are the delays that can be seen in an updated program and try to find cause. The most appropriate analysis and most widely used in arbitration is as planned versus as built, as John has already explained. And it is an observational technique. So where it is very important for a delay analysis to understand what kind of project he is dealing with. And he should have the knowledge of the project, because the critical path, the actual critical path drawn here is an observational critical path, and the knowledge of the project is very important. You can also apply longest path retrospective analysis, but every time longest path may not be the critical path of the project. So I'll only touch upon these various methodologies which I have done. I'll move to quantum. So what is the quantum analysis?
So basically, quantum analysis involves the prolongation cost, the disruption cost, and the variation cost due to variations, change orders, change in scope that has occurred into the project, and to determine the financial worth of it. The most important thing is what is the objective of a quantum analysis? The quantum analysis is used to bring the party to its original position which it has entered into the project. So for an example, if a contractor has entered into the project and it has faced delays and the prolongation costs are there, so because of those prolongations, what are the additional losses it has suffered which it has not envisaged? If the contractor is not responsible for those delays. Similarly, if the contractor is responsible for those delays, what are the remedies which employer can have? What are the claims which employer can have? So quantum analysis again has to be seen from both sides. So generally, quantum analysis for prolongation cost is carried out in two parts. One is the direct cost and one is the indirect cost. So what is the direct cost? So direct cost is basically about all the direct manpower, direct labor and direct equipments involved in the cost. So basically which were directly involved in the production or construction activities or execution activities of the project. Whereas what are indirect costs? Indirect cost is anything and everything which is in general we call overheads. Now, the word itself says time-related cost for indirect cost. So, irrespective of the progress taken place during a period of time, the time-related cost will incur more or less in the same fashion as the time progresses. For example, rent of an office, vehicle rents, equipment rentals, indirect manpower salaries such as project manager, planning manager, accounts people who are at salary. So these are the fixed costs which are being occurred on monthly basis irrespective of progress that are taking place during the cost. It also involves indirect equipment. For example, a DG generator set used for camp activities or office activities, not for the construction activities. So the time-related cost is basically calculated using the actual ledgers of the contractor. Audit ledgers and audited account sheets, they are taken, and what is the cost that contractor has incurred or the party has incurred during the course of the delay. Now, SCL protocol clearly says that this cost is not claimed for the extended period of the contract. This cost is to be claimed when the delay is actually happening or occurring. It may be within the original contract period, it may be beyond the original contract period. Now the task-related cost, direct labor, direct equipment, subcontracted cost, permits. So these are all actual costs that subcontractor claims are with you. So suppose a contractor is dealing with a subcontractor, it is his responsibility to validate those claims, examine those claims, and if it finds correct, then only it can be passed on to the employer. Basically, about direct equipment and direct labor, we use disruption analysis. So, what is the disruption? Disruption is nothing but loss of productivity. SCL recommends various methods to calculate disruption. Most commonly used are earned value analysis and measured value analysis. Now, we all know what is earned value. Just for the sake of explanation, earned value is the value of work done during the period, in a particular period of time. Now, but most of the time, as John has already said, it is the most typical and most difficult thing to do, and at times analysts end up doing the global analysis. So what generally analysts do, they simply take the entire manpower and they see what was the original planned progress or planned productivity, they compare with actual productivity. SCL protocols calls for a causal link between various disruption events and the actual disruptions that have taken place. But generally, at times we have seen, sometimes experts fail to establish that causal link. And the most important challenge in disruption analysis is to determine, because I have raised this question during my cross-examination, that how would you say that the disruption or loss of productivity is not because of own fault of the contractor, but because of the various disruption events which you have listed in your report, because there is no direct link to it. These are the difficult questions which we generally answer in a disruption analysis. So basic, and third is the quantification of cost into variations. Now, when we are talking about variations and quantum analysis, it is very important to see whether we have an analyst has actually examined the POs, the invoices, and proof of payment made to the vendors, maybe bank statement, finance receipts, and anything. But all these three things will establish the cost that is incurred into these. Now, next is what are the general documents required for quantum analysis? So, which I have, most of them I have covered in my previous slide while speaking about previous slides. So, we talk audited financial statements, interim payment certificates, bill of quantities, accounting ledgers, and various reports, schedule of rates. So, what are documents which establishes what is the cost that has incurred in it are required for the quantum analysis. Now, the most important part, what are the challenges faced by the analysis? The biggest challenge faced by the analysis is the availability of document. So, there are documents which are available, but they are incomplete. Certain documents are not contemporaneous. Even accounting ledgers, I was dealing with a particular arbitration few days back, and the contractor who appointed me as a quantum expert, he admitted that the entries in the ledger may not be for this project only. They might have made entries from other projects as well. Similarly, I'm an expert in ICC arbitration, and the contractors, again, the contractor has appointed me, and it is a UAE-based party. Now, for the direct labor salaries, they have given me pay slips. But the pay slips do not match with the accounting ledgers. Why? Because there is the provision of some benefits which are passed on to people there. They are never part of pay slips, and there is no other document other than ledger entries. There is no vouchers, no journals, nothing available for them. So, as a quantum expert, I don't have a way to certify that cost and bring it in front of the tribunal. So, I had only way just to only certify the cost that is available in the pay slips or journal vouchers. So, audited financial, we have spoken about the procurement. We might have POs, we don't have delivery challenge. We have delivery challenge, we don't have proof of payment. So, there is a lot of incomplete documentation which is seen by a quantum expert at various stages, and that makes it difficult for him to certify the cost which is generally claimed in the pleadings. Similarly, for variations, definitely it is not a quantum or delay expert's role to identify whether it is a variation or not, and you need a subject matter expert for that. But once subject matter expert has said, okay, it is a variation, then the quantification of the cost that has to be paid, that's duty of a quantum expert. Again, here you may find a PO, you may find a work order, there are no invoices, and if invoices there, the proof of payment is not there, or they are calculated cost, they are not actual cost. And the biggest difficulty we face is this head office overheads. Indian law allows us to calculate head office overheads using formulas, but it is always good to have properly accounted statements for head office overheads as well. But 99% organizations do not book their head office overheads project-wise. So again, that data is not available. These are some very common challenges we as quantum analysts use, and I will not take much of your time. So this. Thank you for making things very simple for everybody to understand. Thank you very much. Our next speaker is Mr. Ronak Desai. Ronak is delay in quantum expert. Ronak is actively involved with Society of Construction Law activities. Ronak runs a firm which he heads, which provides delay and on-time expert services. And Ronak is going to talk about very interesting aspect, even which I am eager to hear. Heads of claims for partial and total breach of contract by the employer. I repeat myself, it is interesting topic. Heads of claims for partial and total breach of contract by the employer. So here is start with heads of claims whenever you have partial and total breach of contract by the employer. Over to you, Ronak.
Thank you, sir. I must say here that I started as a construction lawyer. How I ended up doubling up as an expert is because when you get a call from Mr. Ratan K. Singh that you have to conduct delay analysis, quantum analysis, you can't say no. So, cutting to the chase, I will come to the breaches by the employer. Ministry of Statistics and Program Implementation in its latest report dated February 2024 has come out with this data that out of 1,821 number of projects monitored by the ministry, 780 projects are delayed, and in 431 number of projects there is cost overruns to the tune of 4.80 lakh crores. Interestingly, in this particular edition of the report, Ministry has gone on to summarize the delays or the breaches by the employers, the prominent reasons for the time overruns. I'll read out to you some of those listed delays. It reads delay in land acquisition, delay in obtaining forest environment clearances, lack of infrastructure support and linkages, delay in tie-up of project financing, delay in finalization of detailed engineering, change in scope, delay in tendering, delay in ordering and equipment supply, law and order problems, geological surprises, pre-commissioning teething troubles and contractual issues, inadequate manpower, delay in technical approval, encroachment, litigation, especially vis-a-vis NGT, that is National Green Tribunal, and state-wise lockdown due to COVID-19. Similarly, in December 2023, when we were all gathered during SCL conference, Parliamentary Standing Committee on Transport has suggested that land acquisition is the main factor that causes delayed completion of the project. It went on to say that how it will be solved is by setting up a single window portal that includes all stakeholders involved in the process of land acquisition in the interest of making the process hassle-free and time-bound. Now I'll deal with how this delays play out on ground by touching a couple of empirical evidence data of current projects. NHAI has given this directive in 2014 that contracts for construction of highways will be awarded only after 80% of land acquisition is complete. Land acquisition for national highways is under the National Highways Act 1956. Now, under that act, under section 3D, the land stands acquired once the 3D notification is published in newspaper. However, as per section 3E, the possession can be taken of that particular piece of land only after compensation has been paid to the landowner. Now again, here the compensation after 2014, the land compensation for national highways is paid under the Land Acquisition Act 2013. In Delhi-Bombay Expressway, there are instances where 3D notification was published in 2015. However, under 3E, the compensation was paid in as late as 2022-2023. So that's why delay in giving possession of site is the burning issue that comes in the project completion. Similar instances are faced in the bullet train project, DFCC project,
And the Ministry of Statistics Program Implementation Report it specifically says that out of the 780 delayed projects, the issue is majorly with linear projects, railways, highways. The other delays are this will also be faced in a project of static where it is station like power plants, steel plants. Delay in issuing detail engineering, delay in issuing change order, delay in approval of drawings, vendor list, data design, delay in utility diversion, non-provisioning of construction water, construction power, and delay in payment. Now, heads of claims, my previous speakers have covered. Prolongation claim UT cost will cover overhead cost, additional plant and equipment cost during extended stay, because during the contractual period you will be claiming idling charges due to non-provisioning of work front during the contract period, loss of earning capacity and profits, financing charges, additional labor cost. Then there will be a variation cost. It may include Mr. Sridhar Mote covered variation in detail in the morning session. It can be due to additional quality, extra item, change in method, change in sequence, type of foundation, change in type of structure, additional requirement of equipment, manpower, additional test, and there will be claims vis-a-vis delay in payment. These are the claims arising out of contractual provisions. Now, there could be claims under the Contract Act. The recent judgment, which is widely debated, is MBL infrastructure, which is given by Delhi High Court, in which it is ruled that tribunal cannot deny damages on the basis of contract terms that restricts the remedy only to extension of time. There is no fetter on the tribunal's power to award damages under Section 55 and Section 73 of the contract. Now, SCL delay and disruption protocol, how it deals with the component of compensation. So, out of 12 or 13 golden principles that SCL delay and disruption protocol prescribes, there are 3 which relates to compensation. First is entitlement of EOT does not automatically lead to entitlement to compensation. Second, claims without substantiation is discouraged by the protocol, that is global claims. The third is very important, where delay analysis comes into picture. For concurrent delays, the contractor should recover only compensation if it is able to separate the additional costs caused by the employer delay from those caused by the contractor delay. Also, the theme of this topic, having touched upon the breach by the employer and the heads of claim, the theme of this conference is how to efficaciously resolve the disputes. So, in view of this ministerial and parliamentary recommendation, which prescribes that there should be a common interface where all stakeholders are on board, so delay in land acquisition, delay in utility diversion, delay in environment clearance can be resolved. The only solution for this can be the Gati Shakti project. So Gati Shakti has 900 of data layers. It includes land, port, forest, highways, railways, telecom, internet, and it's state of the art. It is one of its kind in the entire world. I have a detailed discussion with the Secretary of Department of Promotion of Industry and Internal Trade. So it is implemented by BISAC. It's a national institute called Bhaskaracharya Institute of Space Application and Geoinformatics, and it is based on GIS using ISRO satellite images. So when any highway is planned, there will be 1900 of data layers, and till now the planning of any project was a disjointed planning. There was disintegration, there was no common interface between various departments. 150, there are 39 ministries and all states are on board, and 150 projects worth 12 trillion are are executed under this Gati Shakti project. There are, if you read about Gati Shakti, there are many instances where issues like land acquisition, delay in utility diversion are ironed out in real time. Apart from this, I will, on a lighter note, I'll say that Empire State Building, it was constructed in 19, I have a slide of it. When you visit the museum on the 101st floor of Empire State Building, there is a life-size construction schedule that all of us use daily. It was completed in 1 year and 40 days, exactly as per the baseline schedule. There were 47 activities, only 47 activities. Still, it was completed in time. Activities included starting from foundation till the window fixture. And remember, this was a century ago, almost a century ago, in 1930. And Gantt chart, on the basis of which the construction schedule is made, it was invented by Henry Gantt just 15 years ago, in 1950. So if you look at Notre Dame in Paris, Eiffel Tower, the Gantt chart was not in play during those times. This was perhaps the first project which was, if I can have that schedule,
Okay. We'll try.
By the time we have that schedule with us, it's a very aesthetic schedule, speaking span.
Up. Because we are on the team screen.
In the end, I'll say, when you leave this building, this magnificent building which is of Western, it has in the porch Western classical style Doric columns. On the right hand side, next door, exactly the same building is reconstructed. Exactly the same building, carbon copy of this building, which is under construction. And if you look at the construction on the face of it, the workmanship, the quality of brickwork, plastering, staging, shuttering material, equipment, you can say that this building will be completed in time without any cost overrun. So, as we, and one thing Mr. John said that he visited Bangalore 12 years ago, and then en route hotel from airport, he saw lots of construction being done, and 12 years down the line, he faced the same scenario. First thing, we won't let you wait for 12 years to come here again. And when you come here again, the projects which are under construction now will be long completed, and Bangalore is coming up with mega projects like Bangalore Suburban Rail Project, Bangalore Peripheral Ring Road, Bangalore Chennai Expressway, Bangalore Vijayawada Expressway. So infrastructure is a buzzword in India. Empire State is a, why should we take an example of Empire State when we have in recent times completed marquee projects in time. So yes, we can do it. That's the point.
Thank you, Ronak. Thank you. Now, we have had experts talking about their experiences, delay in quantum. Now we will have political side of this, and that is principles of award of damages and burden of proof. That is where things start. And for this we have none other than Mr. Tejas Karya, who heads dispute resolution practice of Sadhguru Mangaldas, and he is the vice chair of Society of SCL from very beginning. Over to you, Tejas.
Good afternoon, everyone. thank you to Manipal Law School and especially Professor Venkat for this invitation. It's always a pleasure to be here and speak along with the esteemed panel I have. So we all heard about how to calculate damages and how to present the case, the expert's perspective, and also the arbitrator's perspective. But what are the general principles which we have to follow for award of damages, and who has to prove these damages? Because there are both parties, and we have seen in claims there are construction projects. Of course, we heard very positive side from my friend Ronak that we have the project completed in time, and that's the idea. Nobody wants to do project beyond the stipulated time. But there are practical difficulties which are beyond control of the parties, and they have to come back with the claim before the arbitral tribunal. And when it comes before the arbitral tribunal, what are the options available to the parties in terms of types of damages, how to prove those damages, and who has the burden of proof? And at the time of award of damages, what are the various principles which the tribunal which has to award damages? Because it's very easy to argue on one side or to present a case from the expert side, but it is for the arbitrator to decide. And we all sit as an arbitrator, and most of us in this room have either appeared as a counsel or as sat as an arbitrator. It is very difficult to decide because there are lacuna in presentation of the evidence also, and we have to then decide on the basis of whatever available facts and documents on record. So when we talk of types of damages, we have various types of damages, especially it can be categorized into various types, basically in general and special damages. These are the general and special damages which arise in the normal course of events and known as general damages, where special damages are those that arise under the circumstances which were reasonably anticipated by the parties when they entered into the contract. As against that, the nominal damage is can be awarded when there is no actual loss or injury caused to a party against whom a breach has been caused, or in the cases where there has been a violation of a legal right without any actual being proved. So these are not nominal damage. It's not an actual loss, but just to prove a point that a breach was committed and there was a suffering. It's a notional suffering, then you can award a nominal damages. But in contract, we have seen that it is mostly the type of damage which is there is an actual damage which we have to prove before the arbitral tribunal. Now, the substantial damage is something which is awarded when extent of breach of contract is proved, but there are uncertainties regarding the calculation of the damages. So therefore, the substantial damages, when you can't prove, there is uncertainty with regard to what is the extent or the calculation of damages there, then you have to, the type of damages will be called as substantial damages, and speculative damages which are not proved, and this is based on the conjunctures. For example, when the damages are uncertain or contingent on certain event, you can't prove unless that event occurs or that there is a unlikely event which may or may not happen, then that is all speculative. Or the amount of that cannot be ascertained. So therefore, again, it's a speculative damage which we cannot award in the law. Aggravated or exemplary damages are damages where you have an intention to cause damage. So the intention part has to be proved in addition to the actual loss, then you can ask for aggravated damages. Whereas exemplary damages are punitive in nature, is more of a penalty that is intended to punish the other side and not the actual loss which has been suffered. So it is a punitive in the nature, it's a deterrent that we have that kind of a damages so that the party who has suffered the loss is put to the penalty on the basis of those events which have taken place. Now, most common category which we always talk in the construction context is liquidated damages and unliquidated damages. Now, in every construction contract, we have mostly the concept of liquidated damages, where it's a genuine pre-estimate of the loss at the time of entering the contract. And there is a lot of jurisprudence on this. We will slightly go into detail because this is a substantive topic which we are dealing with it after hearing the various aspects of how to calculate the damages. So liquidated damages parties may provide at the time of entering the contract as well, whereas unliquidated damages are awarded by the tribunal and the courts on the assessment of the loss or injury caused by the party suffering such breach of contract. So therefore, for unliquidated damages, you have to actually prove the actual loss as well as the extent of that actual loss. Whereas liquidated damages, so long as you can prove some loss, the parties can agree to limit the liability when it comes to the liquidated damages. What are the principles of award of damages? Now, if you see the basic principles of award of damages, what liquidated damages is defined in the Black's Law Dictionary is a contractual provision that determines in advance the measure of damages if a party breaches the agreement. So this is in advance we are agreeing that this will be the loss when there is a breach. Section 74 doesn't use the word liquidated damages, but it lays down the principles of law governing the liquidated damages. In the pre-lunch sessions, we have heard about Section 74, Mr. Kavi, and Anirudh has touched upon this. But what Section 74 clearly states is there are conditions provided for grant of liquidated damages. That is, when a contract is broken, if there is a sum which is already provided under the contract, then a contract contains that stipulation by with a penalty. Either of the situation, either you have a sum defined or there is a penalty provision. The party complaining of the breach is entitled, whether or not the actual loss of damage is proved to have been caused thereby, to receive a party from who has broken the contract reasonable compensation. Now, kindly mark the word reasonable compensation, and that is where we have seen the jurisprudence is that there has to be some actual loss, and it is not that without even proving the actual loss, you can get the stipulated contract, stipulated damages. The real objective of this incorporating this provision under the Contract Act, which has stood the test of the time, is to avoid unnecessary dispute or litigation with regard to proving the actual loss and also providing commercial certainty. It limits the liability of the party. So therefore, there are threefold protection under the Section 74. First, for the injured party, it affords the only possibility of compensation of the loss that cannot be proved with sufficient certainty. Secondly, for the party who has committed a breach, it has an effect of limiting the liability, and generally for the tribunal and the parties, it saves the time of the witnesses, the arbitrators, and the lawyers involved in the entire process. Therefore, the Section 74 deals with the measure of damages in two classes of cases. The first is where the contract names a sum, which is a liquidated damages, and secondly, where there is a penalty provided under the contract. Now, Section 73 talks about unliquidated damages. Now, Section 73 provides that following a breach of a contract and the injury resulting from such a breach, the party should be compensated as if there was no breach. So that the party should be put in a position if the breach would not have been committed, that is a but-for test has to be applied for. Now, difference between 73 and 74 is that 73 there is no liquidated sum which is genuine pre-estimate of the loss at the time of entering the contract. Whereas in 74, the contract has a certain sum stipulated as a compensation which is provided under the contract itself. Now, if you see the causation, without there being a causation, there cannot be any damages. So, to claim a damages or affixing a liability on a party who has committed a breach, there has to be a causal connection between the breach committed and the loss of injury suffered. So, there has to be direct nexus between the cause of the breach and the damages. For deciding this question, as I said, but-for test has to be proved as without the breach, there cannot be any damages. This has been held by Delhi High Court in National Insurance Company versus Meenakshi Gupta. Remoteness of damage is also discussed by Mr. Kavi in the previous session, where Headley versus Baxendale says that the loss and the reason for loss, there has to direct nexus to the breach, and if there is a remoteness of damages, then it cannot be awarded. So therefore, it has to be arising naturally according to the usual course of the things from the breach, or it might reasonably be supposed to have been in the contemplation of both parties at the time they made the contract as the probable result of the breach. So either parties contemplated at the time of contract, or it is a direct and immediate cause for the loss which is being suffered by the party. At the same time, the party who is the victim, or the party who is not committed a breach, also has a duty of mitigation. Now, this duty of the mitigation is to take a reasonable step to mitigate the loss which the party has suffered, and this is not the right given to the party who has committed a breach, but it is definitely the tribunal has to take into consideration while awarding the damages, then what was the duty of the mitigation of the party who has not committed a breach and what steps have been taken. For example, if there is a delay in supply of the material without seeing the competitive price, the party cannot go and buy something which is very, very expensive in the market and then claim the differential price from the party who is submitted.
Live ಅಲ್ಲೆಲ್ಲ ಸೌಂಡ್ ಬರ್ತಿದೆ ಇವೆಲ್ಲ ಸೌಂಡ್ ರೇಡಿಯೋ ಬೇಡ ಸೌಂಡ್ ಬರೋದು ಆನ್ ಮಾಡೋ ಲೈವ್ ಅಲ್ಲೆಲ್ಲ ಸೌಂಡ್ ಬರ್ತಿದೆ ಬೇರೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ
stipulated in terror, which is the object of coercing a party into performing the contract. So if penalty is a deterrent where a party will perform the contract, in absence of that, the party will have, the person has to be compensated. So penalty is something more than what was actually suffered. The amount quantifies the penalty of the sum named as extra vacant and unconscionable, and it is also a penalty if the amount payable exceeds the likely damage, actual damage of the party who has suffered them. The liquidated damages are genuine pre-estimate of damages, whereas liquidated damages cannot be a penalty. So even if you see section 74, there are two types of damages. One is liquidated damages and the other is the penalty. Now, in terms of case law, Madras High Court has held that the primary test for identifying and distinguishing between the liquidated damages and penalty is whether, when tested as a contract formation, the stipulated sum bears a reasonable correlation to the anticipated loss. If so, that would be a liquidated damages, and if not, it is a penalty. So if it is a direct correlation between the likely breach and a genuine pre-estimate, then it is liquidated damages. Otherwise, if it is any arbitrary sum, then it would be a penalty which will be not enforced. So just to summarize, what is the prerequisite for grant of the liquidated damages? Firstly, there has to be a breach of contract. Secondly, there has to be a proof of damages. Proof of damages, in addition to that, there has to be causation. It has to be direct nexus. There should not be remoteness of damages, and mitigation should be there and is to be taken into consideration. So these are the prerequisites for grant of liquidated damages. As far as the construction disputes are concerned, we have seen that there is a lot of delay. We have already spoken about the delay, and therefore, reason for this delay can result into the claims of expedited performance, effort to reduce productivity, disruption, consequences of termination. Those are the kind of damages which we have seen. So there are two basic approaches in construction dispute. One is the global claim approach. In this, when a contractor asserts that is a global or total loss was a result of the employer responsible events or other causes without attributing that loss to a discrete event or a cause. So in short, what it means is the contractor may seek to deduct its tender sum from its total actual cost and claim the differences. This is a global claim approach. And the second approach is a total cost approach. In this approach, a top-down assessment is made in which the starting point is to full and total cost incurred, but this approach is modified to exclude the items of the cost that can be identified and attributed to a contractor caused events, such as the contractor inefficiencies and variations. So the total cost, where you can identify certain aspects that is removed from the total cost, and that is how it is calculated. As far as delay cost is concerned, delay-related costs are the damages or compensations awarded to an injured party in the event of a delay on a construction project. And the critical factor for that is a calculation is to assignment of a liability for the delayed sufferer, and in the event of contractor caused delay, most standard form of construction contract contain provision for liquidated damages as an exclusive damages remedy for the employer. And for employer caused delay, a contractor will be entitled to a compensable extension of time award, and not all extension of the time award will result in an award of damages. So you have to be going by case-to-case basis for award of damages for the delay. Now, in terms of delay in construction projects in India, we discussed about the Northern Railway versus Sarvesh Chopra matter in the morning also. What the Supreme Court has held that in spite of there being a contract between the parties, wherein the contract has undertaken not to make any claims for delay in performance of the contract occasioned by the act of the employer, still a claim can be made under three circumstances. If the contractor repudiates the contract, second is the employer gives an EOT, and the third is the contractor makes it clear at the time of the grant of EOT that they will accept the performance provided there is a proper compensation. So in these circumstances, even if the contractor is saying that they will not claim any compensation for delayed performance, they can claim the delay. That is what the law has been settled. Now lastly, burden of proof. The burden of proof is on the party who asserts a claim. So therefore, the liability to pay damages would arise only if there is a breach of contract, and to establish the breach, it has to be adjudicated upon and not merely decided by the parties. Breach of contract can be described as a violation of the terms of the conditions of the contract which were agreed by the parties at the formation of the contract. So you have to have a clause under the contract. The tribunal cannot go beyond the terms of the contract for awarding the damages. And the initial burden of proof is upon the claimant who has suffered the loss, and if the claimant cannot succeed in the weakness of the defendant and has to be succeed on his own. So it is the burden is always on the claimant or the counter claimant to prove the actual loss. Now we have seen these cases being cited in the first half. Fateh Chand was the first case way back in 1964 where the principles of awarding the damages and burden of proof have been laid down clearly by the Supreme Court, where the Supreme Court has held that the jurisdiction of the court to award a compensation in case of breach of contract is unqualified except as to the maximum stipulated. So that is a, as far as the liquidated damages is concerned, there is a cap, and beyond that, what the parties have agreed, the court cannot grant, that is the maximum they can grant. But the compensation has to be reasonable, and that it imposes upon a court a duty to award compensation according to the settled principles. In Mola Bucks, subsequently, the Supreme Court has held that it is true that in every case of a breach of a contract, the person aggrieved by the breach is not required to prove the actual loss or damages suffered by him before he can claim a decree, and the court is competent to award reasonable compensation in a case of which even if no actual damage is proved to have been suffered in consequence of the breach of contract. So this is the case where in Mola they said you don't have to prove an actual loss, so long as it is reasonable and the parties have agreed, that has to be proved. But subsequently in ONGC and in Kailashna, the position has been clarified by the Supreme Court, and this is the final position which is still good, is that when a sum is named in a contract as a liquidated damages payable as a damages, the party complaining a breach can receive as reasonable compensation such liquidated amount only if it is a genuine pre-estimate of damages fixed by both parties and found to be the same by the court or the tribunal. So therefore, it has to be agreed between both the parties. It has to be genuine pre-estimate of loss at the time of the contract, and that has to be found to be reasonable by the tribunal. And in cases where the amount fixed in the nature of a penalty, only reasonable compensation can be awarded, not exceeding the penalty so stated. And in both cases, in liquidated damages and penalty, the liquidated damages or the penalty is the upper limit beyond which the tribunal cannot grant the relief. The reasonable compensation will be fixed on the well-known principles of 73. So 74 is now linked with 73. Therefore, you cannot grant liquidated damages without reference to 73. Since Section 74 awards reasonable compensation for damages or loss caused by a breach of the contract, damage or loss caused is a sine qua non for applicability of this section. So without any damage, you cannot claim liquidated damages. This provision applies whether the person is a plaintiff or a defendant, is a claimant or respondent in arbitration. The sum spoken of may be already paid or payable in future, and the expression whether or not an actual damage or loss is proved to have been caused thereby means that where it is possible to prove the actual damage or loss, such proof is not dispensable. So this is slightly different view from Mola-Bucks, and this puts a party under obligation to prove some actual loss and if it is possible. If it is only in cases where the damage or loss is difficult or impossible to prove, when the liquidated amount damage is provided under the contract, which is a genuine pre-estimate, then the liquidated damages can be awarded. And Section 74 also applies in the case of forfeiture of earnest money under the contract. But if the forfeiture takes place under the terms and the conditions of the contract of the public auction before the agreement is reached, then 74 would not have any application. When in the context of arbitration, recently Delhi High Court has held that if the arbitral tribunal found that the stipulated damages were genuine pre-estimate of the loss, it was not open for the tribunal to reduce the same on a guesswork. So tribunal has no power. If the tribunal thinks that the liquidated damages is genuine pre-estimate, they cannot reduce it by doing guesswork, and after having concluded that it was not possible for the petitioner to quantify the damages. In Bhopal Dal Udyog, also the High Court of Delhi, relying upon the judgment of Kailash Khan, has held that the actual damages suffered by the respondent were proven and accepted by the arbitrator. The liquidated damages over and above such actual damages could not have been awarded. So if you are granting actual damages, then in addition you don't have to grant liquidated damages. Either you grant liquidated damages or the normal damages. So this complete discussion gives us an indication that it is important to ensure that the damages are categorized in either in liquidated damages or unliquidated damages, and there has to be an actual proof. Many times what we see is that we file a lot of evidence before the tribunal, but we don't show the cause of the damage and the actual loss which has been suffered. Therefore, quantification and liability both are very important when it comes to the proving of damages, and these are the principles which are very well laid down now, and the tribunals have very simple duty to ensure that these principles are fulfilled if the arbitration is seated in India and governed by Indian law. With that, if you have any questions, we'll be very happy to answer.
Any question? If you have an audience, we'll take one question. Else, now, since I don't see any question coming, on the quantification, you have a question? Yes. Somebody can give the mic, please.
Mic or paper?
Okay, you please ask it. Okay, I think loud and clear.
Yeah, you are loud and clear.
My name is Abdul, but I'm working in data consulting. My question is regarding burden of proof. Proof what documents we have to give in the arbitration. Whether emails or emails, diary notes are considered as a proof in the arbitration.
Yes, so now mostly what we see is that all the correspondences are exchanged by the email. And as the Evidence Act does not strictly apply to the arbitration proceedings, you can rely upon the email. If the existence of an email is not is disputed, then you will have to prove the email by way of an affidavit. 65B does not strictly apply to arbitration proceedings. And as far as notes are concerned, the person has to come and prove, because this is not a note which is contemporaneously sent to the other side by the minutes of the meeting. Definitely that can be relied upon. Or if other side objects, then the person who has sent that document or the person who has is the author of that person has to come and lead the oral evidence. Otherwise, the document itself is sufficient. If it is a contemporaneous, many times what happens, emails are responded by each party because there is a continuous correspondence between the parties, and that is easily can be based on record, and the tribunal can rely.
And Gmail also okay. The company email is not
No, so long as there is no doubt about the existence of a document email being sent, then there is no difficulty. If there is a question with regard to the existence of a document, that has to be then proven if the other party denies that.
Yes, and minutes of meeting need to be signed or circulation is sufficient.
If it is attached along with an email and that email is received by the other side,
Thank you. There is a problem though. Problem is, if this was a manufactured email, there are emails and there are acts which can antedate emails. So if it is antedated email, created today, showing it to be of 3 years back, then it is a problem. but there is a solution too. There are apps again which can decode and identify whether it was a false email or not. So therefore we got to be aware. On quantification, I'll give you 4 letters and that will sum up the whole controversy. Remember CEES. All have talked about this. I'm summarizing it. It is CEES. Cause, effect, entitlement, and substantiation. If you have these key 4 letters in your mind, as a contract manager, project manager, lawyer, and arbitrator, you will never have difficulty insofar as quantification and substantiation of claims are concerned. With this, ladies and gentlemen, I request all of you to join me in giving a big round of applause to all my panelists. Ladies and gentlemen, thank you very much. Thank you very much.
Thanks to Professor Ratan and the entire panelists. I now request Mr. Pradeep Mokshivangam, Senior Vice President of Protocon Private Limited, to please come out to the dais to do the honors on behalf of Manipal Academy. I request Mr. Ratan Singh to kindly step forward to receive the honors. Ladies and gentlemen, please applaud Mr. Ratan Singh with a round of applause. We are so very fortunate that we have him today. Normally we see him on YouTube or online on some international forum, and it's very fortunate that he is with us in person today.
Okay, thank you.
Thank you, sir. May I request Mr. John Prudu to please step forward to receive the honors. Thank you, Mr. John, for having come all the way to Bengaluru and sharing your erudite views here.
Bro, what do you think, bro? Pleasure.
Thank you.
Wait. Okay, thank you.
Mr. Tejas Karya. Thank you, Mr. Tejas Karya. We applaud Mr. Tejas Karya for his nice and very detailed PPT presentation. Mr. Ronak Desai, may I request you to please come to the podium. Thank you, Mr. Ronak Desai. Thank you, sir. Mr. Mahan Singh Thakur. Thank you, Mr. Nayak, on behalf of Manipal Academy. Thank you. Thanks, Mr. Pradeep, for honoring our esteemed panelists. Over to you, Professor.
Yeah, this session is done.
Thank you very much.
Mr. Sundaraju? Yes. Okay. Thank you very much for joining us. So we have been felicitating the speakers. In addition to that, we want to felicitate 4 other persons. So when we started our contract management online program, so we had a lot of tutors who have been tutoring us in the program. So I would like to invite Mr. Ganesan. He is my mentor and he is my college senior and he was my colleague in Bahrain for several years. So when I floated that idea, he was the first one to extend support. And he was tutoring at IIT Madras for a similar program, and where I was invited to give guest lectures for many years. So I have great pleasure in felicitating him as part of MLS. I would like to invite my director, Dr. Avinash,
to come over. The other person is Venkat Rangarao. Again, we have worked in many projects in the United Arab Emirates, where he was my main contractor, I was a subcontractor and various roles. He is a risk analyst and he is working in General Electric India, handling several arbitrations across the Southeast Asia, Nepal, India. And he has taken his classes sitting in Laos and various other places during the programs. Thank you very much, Venkat. You please stay, sir. A lot of people have helped us to put this conference together. My colleagues, my director, MAHE, MLS. Outside, there are two significant people who helped us to do this event. One is Mohana from Delhi. She's working for an infrastructure company and she was part of Society of Construction Law Conference. Because I have no experience in doing a conference, so every time I need to call her and ask, how do we do that? And she has flown from Delhi for this conference. So we have great pleasure in appreciating her efforts. And Mohana. While Mohana did whatever she could do from Delhi, we had a local person, engineer Girish, who has been instrumental in making this program a success. I think most of you sitting here who have come from Bengaluru will know him because, but for his efforts, I don't think this conference would have been possible to get this much delegates. Sincere appreciation to him and great efforts, Girish. Thank you very much. Okay. That marks the end of session 3. We have one more session to go. You survived this long, please stay for another 45 minutes. The tea will be getting hot. Maybe after the 4th session, it will be served outside.
So the next session is themed with this particular topic, though it's a concluding session at a very interesting session. The theme is dissecting disputes, a legal roadmap. And to moderate us, we have no one other than Professor R. Venkat, who we would like to really hear to know how erudite and deep he goes into the subject. In this panel, joining Professor R. Venkat are the esteemed speakers, Mr. Ganesh Chandru, from Dava Associates, Chennai, and Mr. Rajiv Dwivedi, Mr. Inba Vijayan, Mr. Ratan Singh, and Mr. Kirandeep Singh. Request all the esteemed panelists to please join Professor Venkat on the stage.
Bro, ಅದೇ ಮೈಕ್ ಪುರ ಕ್ಯಾಪ್ಚರ್ ಆಗ್ತಿರೋದು
ಗೊತ್ತಾಯ್ತು.
ಆ ಮೈಕ್ನ ಹಿಂಗೆ ಹಿಡ್ಕೊಂಬಿಟ್ರೆ ಹಿಂಗೆ.
Hi Kiran, how are you?
Can you hear us, Mr. Kirandeep Singh?
Hello. Not very well. It's been in and out throughout the seminar, so yeah. But can you hear me?
Yeah, we are able to hear you, Kiran. I hope you are able to hear us.
Yes.
Okay. Since you've been waiting for a long
But
time.
I can't hear you. I can't hear you very well.
You can't
but
hear
it's
me.
okay.
You're okay now? Are you able to hear us?
Yes.
Kiran, in case, just increase your volume on your laptop, just in case if it is just check if it's 100. You okay now? Are you able to hear?
Yeah, I'm able to hear. It's just that it's because I think of your. Never mind, it's okay. It's the distance from the speaker, so your voice goes in and out.
Oh, I see. Okay.
Yes.
We are just waiting for Ratan Singh to join after bio break, I think. So we will start.
ಇದಾ ಏನಾಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅಣ್ಣ ಯಾರಿಗೂ ಕ್ರ್ಯಾಕ್ ಬಂದಿತ್ತು ಗಮ್ ಹಾಕಿದ್ದೀವಿ
Ratan Singh.
ಏನಾಗಿದೆ
Okay, Kiran, we want to start with you. If you have any presentation, please go ahead. Kiran, you are muted. Kiran, you are muted.
Yes, can you see my presentation?
Yeah, we can see and we can hear you.
Okay. I'll just put it on. Yeah. Are you able to see? Are you able to see the presentation?
Yes.
Okay. Alright, good evening everyone. My apologies that I cannot be there in person. I wish I could be. I've never been to Bangalore before, and it would have been great if I'd been there in person. Today I'm going to speak about enforcement of arbitral awards in India. And before I begin, let me just say I am not an Indian qualified lawyer. There are far more qualified Indian lawyers sitting on the panel. Please, during the panel discussion, if I do say something that is not correct, please correct me. I am teachable in that regard. So let me just begin. The Indian arbitration regime, and as you know, the act that governs arbitration in India is Arbitration and Conciliation Act of 1996. And there are two relevant parts to this act. We've got Part 1 and Part 2. So Part 1 deals with arbitrations conducted in India, whether they are domestic or international arbitrations, and the enforcement of orders under Part 1. So if you look at Section 2.2 of the Act, it says that this part shall apply when the place of arbitration is in India. So you can get international arbitration, and but if it's the seat is in India, or the place of arbitration is in India, that means the seat is in India, then Part 1 of the Act will. Part 2 deals with the enforcement of foreign awards. That means enforcement of awards that do not have their seat in India. Now, very quickly, grounds for setting aside. So if you have an arbitral award, that award can be set aside on very limited grounds, or you can resist enforcement of the award on very limited grounds. Now, the first two I want to highlight is Section 13 and Section 16 of the Indian Act. So Section 16 allows for a challenge to an arbitrator for lack of independence or impartiality or lack of qualification. And Section 16 allows the tribunal to rule on its own jurisdiction when it comes to the existence or the validity of an arbitration agreement. So Section 13 and Section 16 provide two grounds for applying to set aside or resist enforcement. Basically, if you say the arbitrator lacks independence or impartiality or lack of relevant qualifications, or if you say the tribunal has got no jurisdiction because there is no valid arbitration agreement or an arbitration agreement does not exist. So the procedure is the first instance challenge shall be before the tribunal. So you make the challenge to the tribunal. If the challenge is rejected, then the tribunal proceeds with the arbitration. And under the Indian Act, you can apply to set aside on these grounds if you're not satisfied with the award of the tribunal or the tribunal's decision on jurisdiction. You can apply to set aside under Section 34, but only after the award is rendered. So contrast this with the model law, which says that you can actually apply to reverse the decision of the tribunal within 30 days of the tribunal rejecting the challenge. Now, grounds for setting aside an arbitral award, these are set up in Section 34 of the Indian Act. So what we're dealing with is here, you have an arbitral award, if you want to enforce it, and the other party is applying to set it aside, and under the Indian Act, there are limited grounds for a domestic award to be set aside. It means an award under Part 1 to be clear. So Section 34 sets up the main grounds for setting aside an award. And these are basically the reproduction of the model law grounds. Now it says in Section 34 only grounds, but that's a bit misleading because I have already pointed out Section 13 and Section 16, which deal with two other grounds, namely lack of qualification of the tribunal or the lack of or the absence of a valid arbitration agreement. So now the other grounds are the model law grounds, where you can apply to set aside, and we have not put them on the slide, but basically model law grounds are if you can argue that one party was under some incapacity, or if there was an invalid arbitration agreement, or if one party can argue that it was not given proper notice of the arbitral proceedings, or you can argue that the award didn't fall within the terms of the arbitration agreement, or the tribunal went beyond what was placed before it to decide. That means it decided on some issue that was not before it. Another way of challenging is, or applying to set aside or visiting enforcement, is on the grounds that the issue was not arbitrable. I mean, you're going on the grounds of arbitrability, or you could also argue that the composition or the makeup of the tribunal was not in accordance with the agreement. And finally, there is the public policy ground. Now, the public policy ground is something that was controversial in the past in India, right? And but this has been quite narrowed down now by the arbitration ordinance, the amendment to the Act. So public policy grounds can only be used if you can show that the award was induced by fraud or corruption, or contravenes the fundamental policy of Indian law, or conflicts with basic notions of morality or justice. But what is very encouraging is under Section 34(2)(a) of the Act, right? This was a result of a series of decisions where awards were set aside because of the wrong application of Indian law. Section 34(2)(a) prohibits setting aside merely on the ground of erroneous application of the law of India or of an erroneous valuation of the evidence. So any court is not allowed to set aside because the tribunal wrongly applied Indian law, as long as it does not contravene the fundamental policy of Indian law, and the court cannot also set aside or refuse enforcement if there is, if it feels that there was a wrong valuation of the evidence. The court cannot do that. So steps for enforcement, very simple. The final award will be enforced as a decree of the court, and it's up to the losing party to object and apply to set aside the award. If your objections are not sustained, the award will be enforceable as if it is a decree or the order of the court. There's a time limit, 3 months from the receipt of the award, on extension of 30 days. So the losing party has 3 months from the receipt of the award to resist or to apply to set aside or to ask the court not to enforce the award. The relevant court that you go to is under the Act, the principal civil court. That means court having jurisdiction of the subject matter. For example, it may be where the assets are, where the successful party has its office, or where the cause of action arose. So it depends, or where the arbitration took place. So which court you go to depends on what you want to enforce, where you want to enforce, what assets you wish to enforce the award on. Now, coming to part 2, so as you recall at the start, I said that the Indian Act has 2 parts, part 1 and part 2. So part 2 deals with foreign awards, okay, awards that are rendered by seats outside India. So these awards can be enforced in India because India is a signatory to the New York Convention, and there are 3 conditions that must be fulfilled before an award can be enforced. First, it must deal with a commercial relationship, right? And that's defined as all relationships of a commercial nature, whether contractual or not. We must first have a commercial relationship. Second, the arbitration agreement must be in writing. So you must produce an arbitration agreement in writing. And thirdly, the country where the award has been issued must be a country that is notified by the Indian government to be a country to which the New York Convention applies. So this ground is a bit more onerous than the normal New York Convention grounds. More onerous and restricted than what is contemplated under the New York Convention, which only requires an award to be in a New York Convention country. But the Indian Act goes on to say that the country must be notified by the Indian government as a country to which the New York Convention applies. So, foreign awards, the grounds are the same for refusing enforcement, as I stated earlier. And the encouraging things I say again is that the Indian courts now construe the ground of public policy in a very narrow way compared to what it was before. So just to round up the procedure for enforcing an award, the documents you require, like I stated earlier, you need the award, you need the arbitration agreement, and you need the evidence to show that the award is foreign, meaning you need to show that it is a commercial agreement, it's an agreement in writing, and that it is issued by a country notified by the Indian government as being a country to which the New York Convention applies. So you need these documents. Relevant court is where the losing party is situated or where the assets of the losing party that you want to enforce on are located. Time limit, none prescribed by the Act, but the high courts have held a residual provision under the Limitation Act of 1963. The Indian Limitation Act would apply. That means 3 years from the date of the award received by the applicant. So once the award is enforced, it can be executed, means it can be executed as a decree of the court. So whatever avenues you have in court to enforce the award, to get your money under the award, that can be used. And appeals, none. There are no avenues to appeal if the objections to the award are rejected. And this ground is something that I'm not so familiar with, but basically it says that there can be an appeal, or you can have a look at if there's a discretionary appeal on a question of fundamental importance or public interest to Indian Supreme Court. So that it seems to be a very narrow ground on which an appeal can be based. That's all I have for enforcement of arbitral awards in India. This is a very nutshell that ends my presentation. I'll be willing to take any questions, Professor Venkat, either now or at the end of the session.
Kiran Deep, I'm Ratan this side. There is one interesting aspect relating to enforcement of foreign law in India. That is, what happens when a foreigner, there is a law passed in a country which is not a reciprocating country. And I, day before yesterday, I argued this case in a civil suit in Mumbai High Court on behalf of biggest producer of oil and gas in Iran. Award is given in Iran in institutional arbitration, under institutional arbitration. But Iran is not a reciprocating country. So as per Indian law, and as per the judgments, we have one judgment of 1965 of Supreme Court, these awards can only be enforced through a process of a civil suit. So you have to take on a civil suit. If it is from a reciprocating country and that country is a convention country, then as you rightly said, that these are the formalities which are to be taken. Okay.
Thank you, thank you.
Okay. So, audience, any questions? Okay. I have just one question. How easy to enforce awards in India as compared to Singapore? The part is, if it is not easy, so what are the practical tips Kiran can offer from his Singapore experience for the practitioners in India?
All right, let me, Professor Venkat, thank you for that question. Let me start with Singapore first. Of course, we know that Singapore is a pro arbitration stance. There's a very strong judicial support to enforce arbitral awards in Singapore. And the reason is because to enforce an arbitral award in Singapore, to resist the enforcement of an award in Singapore, you need to meet a high threshold in order to set aside or resist enforcement of an arbitral award in Singapore. So the courts are very pro-enforcement. The grounds to resist enforcement in Singapore are very narrow. They are the New York Convention grounds, the model law grounds. And that is why Singapore is the choice seat for arbitration. Now coming to India, I think from based on my experience, ever since the arbitration ordinance, the Indian government passed the arbitration reconciliation amendment ordinance, which made amendments to your act. The ability to enforce awards in India is far easier now. I believe because the public policy ground has been narrowed, and the public policy ground has been narrowed to such that you cannot basically resist enforcement or apply to set aside because the law of India was wrongly applied by the tribunal, or the tribunal did not consider the evidence properly. In fact, I think, correct me if I'm wrong, there's a recent Indian decision of the Reliance Infrastructure in 2023, where the Supreme Court of India actually reprimanded the High Court for dissecting and reassessing the factual aspects of the dispute. And the Supreme Court then reiterated the court's review of an arbitral award should not entail a re-evaluation of the evidence, and the arbitral award was not to be interfered with in that way. So, in a nutshell, I think Singapore, yes, we are very pro-arbitration. It's not easy to resist enforcement, but I think India has come a long way, especially with the amendments to the Act. Now, as for practical tips, I think the easiest thing to say is you need to do some research on where the assets are, and you may wish to engage lawyers in the jurisdiction where the assets are to ascertain the extent of the assets, how easily you can get at the assets. So all of this needs to be done as your homework before the enforcement of an award. For example, I am now currently dealing with the enforcement of an Indian award in Singapore. And we are doing the research for the client in terms of trying to identify where the award, where the assets are, and whether or not they can be enforced, whether other parties have an interest in the assets. Now, quite important, even before you enter into the contract, just one final point and a practical tip. Before you even enter into the contract, try and ascertain the solvency of the client, right? If you feel that there is some issue with enforcement or some issue with actually enforcing an award later on, you may not want to make too many advance payments or too large advance payments. You may wish to secure a performance bond or a higher percentage performance bond. You may wish to obtain a parent company guarantee. So all of this, I think, just some practical tips from a construction angle of what you should do. Do homework on your counterparty, how well financially they are, and if necessary, work these into your contract. If necessary, a higher performance bond, parent company guarantee, not making advance payments, etc. So that can be worked into your contract as well. But I think research on where the assets are, that is very important.
Thank you, Kiran.
That's right.
Any questions from the audience? Okay. Thank you for joining. So, our next panelist is Ganesh Chandru. So, he is going to talk about some practical aspects in the arbitration generally. So, I don't think he has a presentation, so I'm going to ask him a couple of questions. So, he will talk through that. The first one is the stamping of arbitration agreements. In light of the recent 7-page judgment, so I would like to ask him what happens to the arbitration agreements which are all unstamped.
I like to be a standing counsel. Even though there is no presentation as such, because at the end of the day, all topics have been covered by other speakers. But there are certain interesting nuances when I spoke to Professor Venkat earlier. I said maybe we should cover these aspects which are practically creating a lot of issues, have been creating a lot of issues in this country, which is now settled by the Honorable Supreme Court. Firstly, thanks so much for inviting me, Professor Venkat, and it's great to be here in this wonderful campus. It is always a pleasure to share ties with my good friend Ratan, Nimba Vijay, of course, Rajiv. It's like almost like a reunion of all the arbitration and construction law practitioners in the country. Great to see John as well. Yeah. And thanks to those who have chosen to stay back on a Sunday evening as well as the Holy Eve rather. See, the aspect I want to just throw light on is in construction contracts, as all of you know, there are not just contracts, but there are several subcontracts. There are a lot of work orders, there are a lot of purchase orders. And sometimes it runs into hundreds and thousands of such orders, purchase orders and work orders. Hitherto, what's been happening is many of these projects, though the work order or purchase order might have an arbitration clause, the practice was, I'm doing such a good project, why do I need to bother stamping all of them, right? So it was literally, not stamped at all. As you know, in India, we have a Stamp Act of 1899. It's a fiscal measure that you need to collect stamp duty on all agreements entered into in this country. And if you look at the state legislations enacted in terms of the Stamp Act 1899, there are certain provisions there as to, it's mostly the amount which will vary from state to state. Now, when you go to court for an appointment of arbitrator, right, if it's an arbitral institution, of course, if parties are not able to agree on a sole arbitrator, you would go to the institution and have the rules it would appoint. But in ad hoc arbitrations, where there's no agreement between the parties on an arbitrator, you typically go to court. And as you know, in a country like India, though we are now trying to promote institutional arbitration in a very big way, and I've been appointed as one of the 3 members of the newly launched India International Arbitration Center, which has been declared as a institution of national importance. While these efforts are being taken recently, most of arbitration in India is ad hoc. I would say at least 95% of it is ad hoc. So in that scenario, courts are on a daily basis, there's so many applications that go before the courts for appointment of an arbitrator. What had happened is, if there is an agreement,
the contract between the parties which is not stamped, then the question before the court arose as whether it can appoint an arbitrator because this agreement itself is, there were views taken that it was not valid. The Supreme Court in SMST Estates as well as Garwar Wall had taken a view that if the main agreement is not stamped, then the arbitration clause contained in that agreement will not work. I mean, it will not be enforceable as the view that the courts have taken. But if you all remember as students of law or arbitration, there is something called the concept of separability, where the arbitration clause is separable from the main agreement. So even if the main agreement is void, you can still look at this arbitration clause separately, and the tribunal has this power called competence to decide whether this agreement is valid or not. And the jurisdiction is given to the tribunal to decide whether it has jurisdiction. So these judgments were actually were not in consonance with the doctrine of separability. Then came the judgment of NN Global, the 3-judge bench, where the court said, hey, look, there's this doctrine of separability. Therefore, even if the agreement is not stamped, the arbitration agreement stands and it's a curable defect. Therefore, the court should be able to appoint an arbitrator. But then, since there were differing opinions, this was referred to a 5-judge bench, and that is called NN Global 2. The Supreme Court, in the ratio of 3:2, the majority 3 judges to 2, went back to the old position, saying if the agreement is not stamped, they will not be able to appoint an arbitrator because the arbitration clause contained in that agreement will also not be enforceable. Of course, this created a lot of confusion in the country because there's so many such agreements which are unstamped. Then the Supreme Court took upon itself and referred this to a 7-judge bench called interplay between agreements entered into where the Arbitration Conciliation Act 1996 would apply vis-a-vis the Stamp Act of 1899. The Supreme Court very clearly said unstamped agreements are enforceable, but they are inadmissible in evidence till such time that they are stamped. So now the position is you go to court, even if the agreement is not stamped, you can still get an arbitrator appointed, but then you'll have to cue the defect and pay the stamp duty. The way it is done is the arbitrator informs this agreement, sends it to the stamp collector, and the stamp collector would collect the stamp duty, and in some cases, a penalty has to be paid 10 times, for example, in some states. But this takes a long time. This process. That's right. There's also a discretion. But this practically takes a long time because we had a matter where the party was in Gurgaon. There was this issue that arose. We tried to do it with the secretariat there in Haryana, and it took about 6 months. In Delhi, I understand it can take 10 months to 15 months to get this stamped. So the point I'm driving at here is many of us are dealing, either as lawyers or advisors or in-house counsel or representatives of construction companies and involved in several projects. Please, this is extremely important. It's a very small stamp duty. It's maybe 100 rupees or whatever. Please advise your clients, or as if you are clients, please ensure that your agreements are stamped, because this is basic. If this is not done, it's going to be allowed to spend so much time, getting this stamped, and the entire process is going to be stalled. And please remember, there's also a time limit within which an award has to be made now, which is 12 months from the time pleadings are closed. And the Act does not give you any leeway where you spend time stamping or you're going to spend time, negotiating a settlement. And this is not excluded. Then you'll have to go to court under 29A to get an extension of time. So to avoid these practical issues, and this is a very welcome judgment by the 7-judge bench of the Supreme Court. Now you can get an arbitrator appointed, but you have to cure the defect. But best is to do it up front. I thought this is some practical tip, which will, in many agreements, especially in construction, there are several agreements around. In fact, I told somebody that why don't you get it done? And the party was saying, I have thousands of these things going on. In one, if there is an arbitration, I'll stamp that. Why should I be spending so much money? So what do? You can only, take the horse to the pond. It's up to that big boiling water. But this has to be done. And I think this balance has been done by the Supreme Court so that the fiscal measure is also not, is taken care of, but the parties get their arbitrator appointed. Any other questions, sir?
Just one small question again. How the construction arbitration is managed in India effectively from its start to getting an award, and how about the court interferences?
Construction agreement, how it's managed in India, I think it of course depends upon project to project. There are some mega projects which are managed very well, and I think that's a very pertinent question as well, Professor, because you're talking about the award at the end of the day. Because what's really lacking, I think perhaps Ratan or somebody when they were speaking earlier during the day were mentioning that when you have construction contracts, the main problem in India, in my view, arises in the way it is managed. During the implementation of the project, the documents that you would need to put in place, for example, I think Ratan was also talking about the critical path. You need to use the software, you need to make sure Primavera or whatever good softwares need to be used so that there is a proper analysis, they are able to do the analysis at the end of the day. If there is a delay, then you will have to look at what is critical path. It means the date by which you need to finish the project is finished within that date. If it's not, then there is a delay. So the critical path has been affected. These things are done properly in very big projects. But if you look at mid-sized and small projects, it's a chaos. And I think arbitrations in India, we are looking at big ticket arbitrations. But please let's remember there are several small arbitrations that are going on arising from the construction infrastructure industry. And the endeavor is what we need to have is trained arbitrators and mediators. That's extremely important. In fact, now in the last 5 to 10 years, we've seen so many of such arbitrators who have already done arbitration who then come and get trained. But that's okay, better late than never. So I think that training of arbitrators is extremely important when it goes into the disputes phase. And during the construction phase, I think the project management is extremely important. And as lawyers, when we start, let us say a client comes to you in a construction project, you need to sometimes think of getting, if it's very complicated, let us say if it's an issue of a delay, whether it be a delay or a quantum issue, or even, for example, a financial aspect that you want expertise on. Sometimes it's good to get expert advice upfront. Even before you put in your statement of claim, you can get that expert. But that expert, of course, cannot testify for you later. So you can get the expert advice upfront as well to assist you as part of a team, so that you can understand and appreciate what these delay events are, whether this was really done as per the critical path, and but most of the times the problem also, Professor, is when, with due respect to the government and PSUs, when they are the employers, you are at their mercy. There is a problem. There will be a delay. For example, you give, let's say it's a project, oil and gas project, and you give an engineering diagram which needs to be approved by the owner. The contract would say once it's within 12 days it has to be approved, and then you have to start working. But then they'll take their own sweet time. And then there's a deemed approval provision. But if you say it's deemed approved and start, and then later they change it, you have a problem. So these are the issues that needs to be done. The second point you made as regards awards, there are two things here. One, once you get an award against an employer, especially a public sector undertaking, right? Hitherto, it was very difficult for you to enforce it because they would typically go to court and file an application to set aside an award because of practical issues that were a problem in India. Because a government employee or a public sector undertaking employee cannot say, okay, I will pay him. There are certain risks that he goes through, consequences that might have. So the government recently, in the last few years, have introduced a scheme called Vivad Se Vishwas scheme, where you have an award in your favor and there's an application pending to set it aside. Then you can, use the scheme and make an application to that government-linked company, and they'll pay you a certain percentage of that, and the case will be settled. I think this is a welcome step that has happened. But courts now are very pro-arbitration. I think they do not really interfere unless there is a flagrant violation of any of the provisions of Section 34. And on the other side, we also need to look at awards made which can be patently illegal, because sometimes there are several people who write awards who do not make with due respect. But the basic format has to be there. They need to tell how they got their jurisdiction. That's why I'm emphasizing again and again on training. I think with that training that we are providing, including what your law school, Manipal Law School, has been doing. I just read the brochure on these LLM programs that you're offering. I think it's fantastic. I think it's first of the kind. I think it's the King's equivalent program was a King's College program, and National University of Singapore used to do an LLM on construction law and arbitration. I should congratulate you. I think that's a great step. And I think with training, definitely the arbitral process will be better. Awards will be much better, written much better, it will be enforced. And in terms of construction management, I think the use of a proper procedure to be put in place is extremely important and paramount for you to ultimately get the benefits of the project, because you don't want to get into litigation unnecessarily or arbitration at the end of the day. Thank you.
Thank you.
Execution of the contract. We are having arrangement with the contractor and client. So we are providing UOT to the contractor, and we are asking the contractor should not claim in later stage. So in this regard, can you please repeat, because during execution of contract, sir, there is arrangement with the EPC contractor. Client is giving UOT. In later stage, you should not claim any providing the UOT. So we have taken undertaking with this contractor, both signing client and contractor. Is it required to be stamped, sir?
This agreement?
Yes, is likely MOU.
But if it's a memorandum, just get it stamped. Because you never know who can raise it. It's usually 100 rupees maximum. If it's in the form of an agreement, but if it's just a letter extending the time and he's signing it, I don't think it's required. But better to, I think.
I think it would be an amendment to the contract, yes, it has to be signed.
Yes, that's what. Any supplemental agreement or amendment to contract? I think it needs to be.
I think it's better. If you are in doubt, please stamp. I'm telling you personal experience. You can't do this stamp.
In Karnataka, they have made minimum 500 now. Only affidavit is 100. All others are minimum 500.
And that's very important for you to look at each state's stamp amendment. If there aren't any other questions, I'll hand it back.
Okay, thanks, Ganesh. So our next speaker will be Rajiv Bedi. So although we have a rules-like procedures of arbitration, I think every contractor or employer would try to use more cost-economical ADR procedures. So that's the reason we get multi-tier dispute resolution clause in most of the contracts. So he is going to take us through how does it help to have a multi-tier and what are the pros and cons of doing that.
Session 4.
First of all, I thank Dr. Venkat to invite me to such a wonderful occasion, and I also wish to convey my regards to all my panelists. The subject which I have been given to speak is that adopting an effective dispute resolution mechanism, including multi-tier dispute resolution process. Now, at the time when we are going to frame an arbitration clause, it is always better and it is always advisable to have a method of arbitration or dispute resolution which is suitable for the particular situation. Several methods have been devised: mediation, settlement, arbitration. Then there have been various combination of methods. mediation, arbitration, arbitration, mediation, arbitration. Then another effective method was dispute resolution board. The basic concept and the basic principle was that the money should continue to pour in during the entire course of this construction process, because normally the construction contracts are a very long run process. There are certain contracts where the construction period is say for 2 years or 3 years, and then there is a maintenance time. So normally the payment portion is long drawn. For example, for annuity based contracts, the contractor has to invest the entire amount upfront, and the return has to come in next 25 years or so by way of a biannual annuity or with annual annuities. The whole thing is that the money must continue to flow while the work is going on. In several countries, there is a concept of security of payment. For example, in Australia, there is a law. In England, also there is a law which ensure that although there is a dispute between the parties, the disputes are being raised, but those disputes are also continuously being addressed, resolved. If either of the party is not agreeable to that, at the end of the whole process, they may raise that as a arbitration or whatever is the method prescribed. So there are all these methods. The question is that which one of them is best, or which combination of them is best. Especially in a construction contract, the ideal situation is that at the outset, a DRB, dispute resolution board, should be formed, and they will just keep on overseeing the day-to-day working of the agreement. So, for example, if some dispute are arising or it is likely to arise, in all the agreements there is a limit prescribed that within 28 days of the dispute being arise, the same has to be notified. There is a very notorious section 53, the first subclause of the section says that within 28 days the dispute has to be notified, although that 28 days does not apply in the context of India. But then clause 53.4, it says that if the dispute has not been raised, then only claim which our contractor can get is what he has been able to establish on the basis of contemporaneous document. Now suppose if there is no contemporaneous document, he is not likely to get anything. Therefore, if this kind of dispute resolution boards are there in place, then he will continuously raise all those disputes before them. Second issue is that of limitation. Many a time when the a construction contract, they carry on for a very long time, and suppose there was some dispute which arose right at the outset, and he thought that I will raise this dispute at the time of all other disputes. It may be very much possible that by the time he will raise his dispute, that first dispute may be time bound. So the ideal combination, which would be the first step, is to form a dispute resolution board, and to form it at the outset. In most of the agreement, the formation of the dispute resolution board is provided for at the beginning of the agreement only. If in case the finding of the dispute resolution board are not acceptable to the party, especially for the government organization, they must record so by way of writing that I am not accepting their finding. What is happening that in many of the cases they just completely ignore the recommendations. By that time, those recommendations they become binding upon them. So whatever is the clause provided for this agreement, they have to be very meticulously followed, and that is what is the part of what Mr. Ganesh Chandru said, that how the contract, the construction contract management has to be done. Because whatever is the part of the agreement, whatever you have entered into, at least go through them, follow them meticulously. Because when the dispute will happen, then why you did not follow it will not be gone into, that will not be seen. Whether it was followed or not followed, that alone has to be seen there. So DRB should ideally be the first step. Thereafter, there are many thought which says that go for mediation. My view in this regard is that that may not be the right time to go for mediation, because when both the parties are very much certain of their cases and certain of winning, they may not be interested for going into settlement and for going into mediation. So the next step should be go for arbitration. Let the issues be framed, let the evidence be laid, test the strength of your case. And then, even as per section 30 of the Indian Arbitration Act also says that it shall not be, the word which is used by the Act is, it said, it is not incompatible with an arbitration agreement for an arbitral tribunal to encourage settlement. That is the ideal time for go for settlement, is when both the parties have actually tested their own strength, they have tested their evidence, they have tested their witness. And that is when they know how much they are likely to get and how much they are not likely to get. Most of the experience ones, certainly they are fully aware of that. So that is the stage when they should ideally go for a settlement talk. There the most important part is that the settlement talk must not take place in front of the arbitrator. It should always be referred to some professional mediation body, some professional settlement body. Nowadays there are so many of them. It must never be before the same arbitrator, because once the settlement talks takes place before the arbitrator and where the parties have, leaving aside the merit of their case, they have come down to a particular figure. Those figures will be stuck in the mind of the arbitrator, that he had agreed to go up till this level. So the settlement talk that must not take place before the arbitrator, the settlement talk should be before a professional body who are duly qualified, duly trained to persuade the party towards a settlement. Suppose if settlement takes place, very well and fine. If the settlement does not take place, they can always come back to the arbitration process. Now, one very interesting point which Mr. Chandru pointed out just now, that section 29A does not contemplate any holiday or any waiver of the period for which the settlement takes place. So, with the consent of the party, they can always go for at least the first extension, or for the second extension also. For the extension part, if the parties have been pursuing their remedy diligently, even the court does not mind that and they allow that. So, ideally the DRB, arbitration, mediation, and if needed arbitration, that should be the ideal kind of a bouquet of the dispute resolution mechanism which is there. There are the pros and cons of both these methods. Advantages that I have just now said, that the timely intimation of dispute, because there is a timeline prescribed where the dispute have to be timely intimated to the other party. There are situations where the employer he is under impression that there is no dispute, and he is also going on with the flow of the time, and at the end of the entire thing, like what Sir said just now, he granted EOT also, he did not levy any LD also, and when everything is done, the contractor turns around and he slaps the last claim on the employer. Then what does the employer do at that point of time? So, if the mechanism is there in place, all the intimation of the disputes are done in the timely manner, employer is also aware, at the same time the contractor, he is also aware that my flow of money is continuously there. For example, this in most of the cases, once the work is completed, then there is a huge claim of idling charges, the huge claim of overhead charges. Now, once a mechanism of like DRB is there in the place, and if he has not raised those claims simultaneously, certainly he would not be in a position to raise these claims, and at the same time there would be no such requirement also. The employer would also be in a position to be fully aware that what is coming before me or what is not there. So the next thing is that the flow of money would continue, the limitation would be saved, the contemporaneous evidence would be available. If a body is there and the documents are being produced before him, that is the main intent of section 53(2), that is the contemporaneous record should be preserved. So that would actually ensure the complete compliance of the agreement in its letter and spirit. Both parties will have a certainty that what is happening. The future of, in most of the cases, if the larger part of the payment is done, I don't think any party would be interested to go in for any kind of litigation. The certainty in any procedure is what is the actual anathema of stopping all these litigations. That may not be very helpful to the lawyers, but that is very helpful for the industry. Then, these kind of dispute resolution mechanism, they are the best suited for at least for the construction industry. There may be some very specific industries where they would like to go for mediation or the settlement thing before they go for the dispute resolution, especially in case of where both the parties are private parties. Because a major problem with the government is, in order to agree for a settlement, they have to take too many of the permissions. And then there is a problem of auditing. If they agree for a settlement today, 10 years down the line, some auditor will come and they will raise the question, why is the government settled for such a lower amount? So that is why we often see from our experience that the government bodies are quite reluctant to go for any settlement. So it is kind of a compulsion for them to go for a dispute mechanism by way of adjudication, and that would be taken to 34, 37, Supreme Court, and all those things. So keeping all these aspects in mind, the dispute resolution process that need to be identified and framed. That is. If any question is there, then we can.
I have a question.
Please.
You said I say DRB like ADR.
Yes.
You can say the application.
Yes, sir.
I don't think so, sir. Because 2.5 years is your claim.
Yes, sir.
You come to that 6 months, you have dragged in DRB. After 3 years, you have gone, you have served an arbitration notice.
Yes, sir.
Will it not be time barred?
No, sir. Once I move before DRB.
No.
Once I move before, see, if the DRB is the first stage, of my dispute resolution process, I move to DRB in time.
Means you want to say that cause of action has not come, but your this thing is rejected. Then
if it is rejected, it is rejected. I move before DRB within 3 years.
No, sir. I think arbitration.
Section 40. I will tell you this. This is a very, very tricky question. Question has been answered by Delhi High Court and Justice Bhagru's judgment that says if you have a contractual provision for DRB, which is a precondition for invoking arbitration, and if you have invoked DRB because it was a precondition for you within time, then limitation will not be.
That's section 43, sir.
That's what. Question is, if it is a precondition for invocation of arbitration, it is a contractual stipulation. You cannot go to this. So therefore you save limitation. That's what Delhi High Court has taken a position.
And then cause of action for going for arbitration does not arise.
Guys, before 6 we have to finish this because people have to catch flights. We have 2 more speakers to go. I think before everybody leaves the hall, I should get this going. So next I would call Mr. Impe Vijay, is going to give tips about choosing an appropriate arbitration tribunal for effective disputes, especially the construction disputes.
The first one. First of all, thanks Dr. Venkat, or Professor Venkat, or Engineer Venkat, whichever reason. This is how a professional person has to get involved into arbitration. And the topic given to me is to find out the dream team. Arbitrators are like persons who are going to dream about who is going to decide their dispute and how the dispute is going to be resolved and the present scenario of the time frame to complete the arbitration. But these are few things what we could just look upon when we want to have a appropriate arbitral tribunal. And most of us would have a question is that if you're going to have more than one arbitrator, eventually most of the construction arbitration we need to have, better to have 3 arbitrators rather than the sole arbitrator. There will always be dissenting opinion, dissenting awards. And in construction industry, it is very, very clear that it is uncommon to have such dissenting awards, at least in my personal experience. People might vary on it. But the variation, particularly on the dissenting part, comes depending on multiple factors like the composition of tribunal, very important thing. All of us expect in a construction dispute to have technical members in the tribunal. In reality, it doesn't happen. It always ends up with persons with legal background presiding as arbitrators, whether it's construction or commercial or whatever. Most of the cases, the stats might say is even above 75%. When you're going to have these legal persons sitting as arbitrator in construction industry, they are much going to rely on third party like experts. The morning you heard about quantum experts. They might depend upon domain experts to have the effective interpretation of the terms and conditions of the contract. It keeps on piling up. The effect of the influence of third party on the tribunal, which is comprising of all the legal professionals. Here, what is the solution? Anyway, it is going to be the major procedural step identifying the arbitral tribunal. It has to be a strategic decision taken by the parties if they exercise their right, what has been mandated to them, instead of handing out to the courts or the institutions. This particular ICC Commission report, I personally felt, is giving some clarity on arbitral tribunals composition. What is it all about? It is just going along with one interesting development in 2024, which is about the IBA guidelines on conflict of interest. You can see 4 lists, which is being brought down here. One we call the non-weighable red list, second one weighable red list, third one, the orange list, and finally the green list. Many of us, at least in India, whether it is a construction arbitration or commercial arbitration, we keep on relying after the 2015 amendment on the 5th schedule, 6th schedule and 7th schedule. For better understanding, it is nothing but a list comprising of all considered to be orange under the 5th and all under the 7th considered to be red. In traffic signal, red, don't proceed. Similarly, when you are going to choose an arbitrator, whether that arbitrator is coming within the red list. And here, the new guidelines are given 2 options. The parties can waive
And in our Act also, there is a provision in section 12, particularly a proviso in it, subsection 5. If the parties agree, they can even choose an arbitrator who come within the ambit of 7th schedule. It might be some 19 categories which has been taken exactly from the red list. But now we have an option, and if you look on the second one, waivable red list, it might be serious but not a severe situation whereby the parties can knowingly agree to waive the conflict. Here we have a practice in most of the public sector undertaking. Earlier, the sitting employees or the existing employees were sitting as arbitrators. Now it has changed, and if you look on the famous DMRC case, it says that choose from a panel of arbitrators provided by one of the party. And if you look on that panel also consists of former bureaucrats, ex-officials from a similar sector institution. Where is the question of people considering to be in the red list? And if you look on the 7th schedule, it also gives a time period. A past relationship going beyond 3 years doesn't matter. Most of our public sector officials who are sitting as an arbitrator even now get a pension. To what extent it might influence when it comes to sitting as arbitrator? With disclaimer, I have to just share this view. But this waivable red list, if it is being taken in the construction industry, to what extent it will have an effect? Can we have an effective arbitration process wherein we can feel impartiality and independence? Getting back to the aspect of arbitrator eligibility and qualification, these are the expectation by the courts as well as by the parties. It might be confidence. Obviously, the party should need a confidence. Expectation is multiple ethical grounds like impartiality, independent, neutrality, integrity, all matters. Construction industry might add on the technical and legal qualification. The law looks into disinterested party to the litigation. But here, another interesting protocol or the guidelines where the CIAM, the Chartered Institute of Arbitrators, wherein Mr. Ganesh Chandru was highlighting that we need to have effective training for a person to act as effective arbitrators. One whole body called Chartered Institute of Arbitrators come with some protocol. But even in that protocol, when you look upon a prospective person who's likely to be appointed as an arbitrator, there is a process of interviewing that person by the parties. No doubt, we are not sure much of what the discussion would happen, what type of interview, but still, the protocol gives the guidelines. That's what we have all been taught before taking into arbitration. A simple understanding is that a person who is going to be appointed as an arbitrator, whatever might be his past, whatever might be his future, when he is going to preside that particular tribunal, the expectation of the parties is nothing but neutrality and a conclusion which is going to be within a reasonable time with reasonable cost. No doubt it is a win-lose situation, it's not a win-win situation in arbitration. As a final point, choosing an arbitrator in India, we can't just go away from all these points. A prospective arbitrator have to look upon all whatever contemplated under the schedules included in 2015. We can expect a reasonably appropriate tribunal with disclosures, whether it is happening in the initial stage or during the process. And if that schedule has been adhered in an effective manner, we can complete that arbitration within the stipulated time of 12 months, including the pleadings time of 6 months, subject to parties extending for another 6 months, 24 months is considered to be reasonable, and now it becomes upon the time frame for a person who is going to be an effective arbitrator. Thank you for the opportunity to share a few thoughts about arbitration. So, audience have any questions? Yeah, one question.
Please, because we have one more speaker to go. Sir, my question is regarding the appointment of arbitrator. So, the contract agreement has a fee structure, which is already mentioned in the agreement, and then the nominated arbitrator, whom we have nominated, he is requesting for the fee structure as per the Arbitration Act. So there is a dispute between these two because the agreement provision is lesser than the Arbitration Act fee structure. So my client is saying that you bring an arbitrator who will agree to the agreement fee structure only. So he is not ready to appoint his arbitrator until unless we get a person who is agreeing to the agreement fee structure arbitrator. So how to resolve this?
Okay. If there is an agreement between the parties for fee structure, unless that is varied, you can't do much. Because there are specific judgments in Supreme Court saying if parties are agreed for something, the arbitrator cannot go and vary that. And also the fourth schedule of the Act is only a guide. It's not a mandatory fourth schedule. The Act says that when a court appoints an arbitrator under Section 11, it can then, look at fourth schedule and say that the fees will be paid according to the fourth schedule to the Act. But many times, yes, even if there is an ad hoc arbitration, when parties appoint an arbitrator, in the first preliminary hearing, you say, sir, would you like to adopt the fourth schedule? We do ask in many cases, the arbitrator also agrees. But in your case, you've already had an agreement for a lesser fees. Unfortunately, you can't do much unless both the parties vary it. The other party does not agree, then you have no choice because that will be a ground on which they can say this is not according to agreement of parties. So therefore, I think you need to either agree with them to say that be realistic, let's at least agree to schedule 4. We did that in one of the cases, in fact. One of the cases with a top PSU for a huge, kind of a contract. It was just 12 lakhs was the cutoff and the claim was 700 crores or something. Then we said at least agree for fourth schedule. Then they agreed.
If you throw peanuts, you get monkeys. That's the problem. While signing the contract, if you set a limit, which is unrealistic, and if you cannot get reasonably good arbitrators, what is the fun of having an arbitration in the first place? Because deficient any award or any decision making which is deficient in quality, it's worse than having no award. So therefore, in first place, you should look at this. But your question is not very peculiar in a sense that there have been many such instances where one of the parties will simply just not agree, particularly the client side. They will not agree to enhance the fee. So there is a problem there, and answer lies in what Ganesh said.
When it comes to fees, it is very well the parties can agree, no doubt. But to have a standardized practice, it is always better at least to consider the fourth schedule, even though it's being a model fee which is being recommended for domestic arbitration. Very well, you can just adopt it. But if you look on in 31 capital A, regime of cost, particularly the last subsection gives, prior to the arbitration, the parties, if they are going to agree upon a specific fees, it is not that it has to be followed as such. Still, the arbitral tribunal can negotiate with the parties and restructure it. There is an option available. But it's better at least to have the mid-sized cases, adopting the fourth schedule until unless doesn't cross 20 crores?
I think recently in the ONGC versus Simplex, so the Supreme Court has given a big ruling on this, and they have insisted that arbitrator can fix their fees, and it's only a guideline. Whatever is given even in the fourth schedule is only a guideline. Only thing is they said arbitrator cannot unilaterally change it later. Without the consent of the parties, he cannot change the fees once it is agreed or presented before the parties. So it's been debated in great length.
If you did not have pre-agreed arbitral fees cap, then what you are saying is, but of course,
ONGC case was also the same. So ONGC has mentioned a price, and ONGC was not agreeing to the arbitrator charging more. That's where it went to the court, and it went further and further and further, and right up to the Supreme Court. So that's what they said. If the tribunal is not accepting, they are free to set their own.
In EFCON, it was not the case of pre-agreed arbitral fees. In EFCON, difficulty was that arbitrator unilaterally increased the fees after having decided the fees in first place. And that was the dispute which went to Supreme Court. Supreme Court said once you have decided this, you cannot unilaterally keep changing it. And that was the problem.
Okay. I think we come to the last speaker, none other than Ratan Singh. So we're going to come back to the same point we have started the discussion in the morning, construction law. The world is round, so the topic has come back. Now we are talking about construction law in India. So he is going to give a perspective with respect to other common law and civil law jurisdictions. Why I have added the civil law here means a lot of contractors from India, they work in Gulf countries and they follow a Sharia-based, a French version of the civil law provisions. So how it is going to be read across between the various jurisdictions and the construction law in India? Over to you, Mr. Ratan Singh.
This is unfair, Professor Venkat. You said we are going to close down at 6 o'clock. This is 6 o'clock. So our time is this. In order to be fair to Mr. Professor Venkat, in order to be in the interest of time, I'll be very brief. I have a slide which I'm not going to run. I'll just talk about few fundamental aspects and philosophical aspects of similarities and dissimilarities between common law and civil law jurisdiction. And I will start with the very basic. I'm not going to give a long lecture. When we say construction law in common law jurisdictions and culture, what is that we are talking about? There is something called common law jurisdictions. What are those common law jurisdictions? So basically, for proper and basic understanding, laws which started in United Kingdom, UK, and which were applied subsequently in the colonies of UK, followed the UK laws, and those countries which are following those UK laws are again called common law jurisdictions. That is the very simple way of asking this. So far as civil law jurisdictions are concerned, they follow the Roman law in essentially. If you see the percentage, in terms of percentage, in fact, 2/3 of world follows civil law. Since we are in common law jurisdiction, India being one of the colonies, so we somehow believe that what we follow in common law is generally followed everywhere. In fact, there are more countries which follow civil laws. So like Europe, most of the Europe, continental Europe, in fact the north of Africa, the South America, Japan, China, even Nepal, they are all civil law countries. Now, what is the conceptual difference between these two set of legal systems. In common law system, judge made laws or the precedents is the basis for decision of disputes. So basically, these are all about what judges decide as the law, which is the source of law in your country as well. So that is primarily the what is called common law country. That is one. Second aspect is, if you see this civil law countries, in civil law countries, laws are codified in great details. So what they follow is codified laws called civil codes. That is what they follow. Now, this is one difference. I'm talking about difference. I'm starting with difference. Second is common law jurisdictions. Historical, traditional. It is adversarial system of dispute resolution, where two sides disputing parties are like two teams playing a football match or cricket match, and the judge or the arbitrator is like a referee who will decide which sides played better. This is what common law system does. When it comes to civil law system, in civil law system, it is different and in qualitative difference. Here, judge or the arbitrator is in the driving seat. So this process is not adversarial, it is inquisitorial, where the arbitrator or the judge takes charge of the proceeding, takes upon himself or herself the obligation and responsibility to find facts, decide cases, even collectivities. So that is called inquisitorial system. Interestingly, in common law jurisdiction, cross-examination is supposed to be the most important tool of decision making or fact finding. What happens in common law jurisdiction is the lawyers of the opposing side will cross-examine the witness of the other side. When it comes to civil law jurisdiction, in civil law jurisdictions, it is the judge or the arbitrator who will cross-examine the witness. And if at all they have to do it, because they believe more on documents. If at all cross-examination has to happen, it will happen through the judge or the arbitrator first. And if you have a good judge or arbitrator, he will not leave any questions for the lawyers. In exceptional cases, you may have the lawyers who may ask you questions. Another very important aspect relating to cross-examination. In common law jurisdictions, you ask closed questions, that is called leading questions, where answer is inbuilt in the question. Like, is it correct that you are standing at this particular site of a particular day? So you want answer in yes or no. That's why it is called closed answer, because your answer is inbuilt in the question. In civil law jurisdiction, it is just the other way around. There in cross-examination, questions asked will be open questions. So tell us what happened on that day, what were you doing, and so on and so forth. So that is again a difference. Another difference in terms of the arbitration, since we started talking about arbitration, the production of documents or discovery. Let's talk about discovery. Now, discovery is a process where one side requests the other side to produce documents which this side says, I do not have, but these documents are relevant for proper adjudication. You can go to an arbitrator First, you request the other side. If it doesn't agree, you can go to arbitrator. Arbitrator can direct the other side to produce those documents. See, in civil law jurisdiction, they look at this discovery with distaste. They don't at all want this. They don't like this. In very rare cases, you will have the whole thing of discovery. So, in terms of processes also, there are many dissimilarities and differences. Now, I now talk about what is the current situation. Current situation is that the similarities in these two legal systems are more than dissimilarities. Now, if you will recall, Lord Wolf's recommendation for changes in the civil procedure rules, we have in India called CPC. In UK, they call it CPR, Civil Procedure Rules. Recommendations were made, and that recommendation of Lord Wolf was again taken forward by Lord Jackson. That is called Jackson. So, what are you seeing in terms of CPR today? You saw in the UK? Case management. The concept of case management came, and now we borrowed that case management concept here in India also. Now you have commercial courts that which talks about case management. What is case management? How the hell typical traditional common law judge or arbitrator would be concerned with case management? Things have changed. Now, case management is a process where judge or arbitrator takes initiative and try to see that everything is being done in a proper manner and what should be done, what should not be done, and all of this. So this is a combination. And this is where this input of inquisitorial system has come in the common law jurisdictions as well. There are many such changes. Similarly, in civil law jurisdictions, now due deference is given to decisions given by the superior courts, so that stare decisis or the law rule of precedent is being followed there also. Obviously, they give lot of importance to academic papers, to literatures. Academic papers in civil law country, they give lot of to jurists, the paper published by jurists. Now, therefore, similarities are now much more in a sense that if you see arbitration or construction arbitration to be specific, now if arbitrator is a trained arbitrator, his entire process will be good combination of common law approach and civil law approach. Sundara was talking about that tribunal will decide how experts should carry out the delay analysis, which method they should go for, how they should prepare the report. What is this? This is what inquisitorial approach is all about. This is what happens in civil law. So there are, and I'll tell you, difficulty today in India is in arbitration. Most of the arbitrators, including the retired judges, most of the time, are neither trained in common law approach of international best practices of arbitration, nor are they well trained in the civil law approach of international best practices. So they fall in this trap here. I'll give you an example. I have had, I get many calls from retired judges who are sitting as arbitrators when they have certain problems. Think about a situation when you are sitting as arbitrator party has done a wonderful job in terms of establishing its liabilities on the liability side. Now, on quantification, relevant evidence is lacking, or there are certain documents lacking on the basis of which quantification can be done, and so on and so forth. There can be n number of situations. What will tribunal do? There are two options. Either tribunal will say, you did not place it before me, I am a common law arbitrator, I simply dismiss the claim. And this is how it happens day in, day out in India. Another approach is that why cannot you decide as an arbitrator, I have something missing. I was sitting as a chairman in one arbitration tribunal. It was a high-stake arbitration tribunal. Sorry, high-stake dispute, construction dispute. There, now the basis on which claim was to be quantified, like the residue of rates, those were not on record. I said, unless you bring it on record, how quantification will happen? So therefore, now, good arbitrator, internationally known arbitrators, are good arbitrators because while keeping in mind the due process, please keep this in mind, while keeping in mind the due process issues, they take good initiative from day one. If you see the procedural order number 1 or PO number 1, which we call it, it is so detailed. They tell you how to write, how many pages of a statement of claim, what should be the size of the paper, what should be the distance between two sentences, so on and so forth. So this is what is, so therefore, similarities and dissimilarities. Now we are running out of time, just one last thing. What is the philosophical difference and dissimilarities between civil law and common law when it comes to construction law? I'll give one instance. In common law jurisdictions, great emphasis is given to freedom of parties when it comes to writing of contract. So it is the freedom of parties so long as it is not hitting the any public policy region or ground, or is acceptable. Like limitation of liability clause. Why it is being made enforced here in common law jurisdictions? Because we give lots of emphasis on freedom of parties. But when it comes to civil law jurisdiction, they say freedom of party is fine, but all should be tested from on the touchstone of good faith of the parties. That makes the necessary change, philosophical change between two jurisdictions and legal system. And now, whether it is limitation of liability clause, whether it is a liquidated damages clause, whether it is force majeure clause, like force majeure. Common law countries, contract governs, contract rules. When it goes to civil law countries, they will see what is reasonable, what was done in good faith. So therefore, if you have to test any legal principle touching upon the construction dispute, and if you are in a doubt and dispute, confusion, just try to test it from the good faith thing, which is larger, you can say that what was, like, I'll tell you very interesting aspect, and just I pose you with it. Now, limitation of liability. Now, invariably people think that if you have a liquidated damages clause, employer or the client cannot claim more than what is written in the liquidated damages clause. Let us say it is a 5% cap, maximum 10% or 5%. There is an exception to it. And there is an exception to it not only in civil law countries, even in the common law countries. If it is hit by tortious kind of act. I simplify it. If, let us say, the employer sets a ceiling of 5%, but employer was grossly negligent. If employer was willfully defaulting this, thinking that I have got a 5% ceiling, what can be done beyond that? But again, in India, nobody has raised this issue in mega arbitration with respect to a thermal power plant 300 megawatt. This is arbitration going on. I have raised this issue. So theoretically, they were different. Now, in international commercial arbitration, when it comes to evidence and taking of evidence, role of experts, appreciation, for all of this, in 70% international commercial arbitration, IBA guidelines on taking of evidence is used. Parties themselves consciously agree to use IBA guidelines on taking of evidence for the sake of predictability. If you look at the IBA guidelines on taking of evidence, if you see the draftsmen, who are the draftsmen, if you see the committee which was constituted for this, it is a mix of from civil law and common law. IBA guidelines on taking of evidence is a fantastic mix of civil law culture and common law culture. But the orthodox civil law arbitration practitioners did not stop there. They came out with prior rules. They said this is what we have as a typical, evidence taking rule that they call it prior rule. So I'll conclude here. I don't want to get into this. My slide is there. Professor Venkat will circulate amongst you. So my only thought is that's like Saudi Arabia did the codification in 2023. It is a Sharia jurisdiction. Again, which is based on Quran. So, and I tell you last sentence. Every jurisdiction, whether it is common law jurisdiction, you go to different common law jurisdictions and you will find their own peculiarities. So it is not that there is one law. Like on liquidated damages, we are talking this morning. Position taken in UK is very different from position taken in India. In Indian Supreme Court has made it more like a general damages. So therefore, again, in these different legal cultures, there are localized dissimilarities. Thank you very much.
You can give the questions to me, we will get the answers later on. I have few questions, but I will ask you to answer it on your way to airport.
Thank you, sir. Now may I request Professor Ganeshan, adjunct faculty, to please come out to the stage to do the honors to the esteemed panelists of the law of MAHE Academy. May I request Professor Venkat to... Thank you, sir. Ultimately, the man behind the show. Let's all please give a big applause. May I request the delegates to be seated? We will close in a few minutes and we will conclude with the national activities. Mr. Ritan Kumar Singh, sir. Thank you so much, sir. Welcome.
Please. Prize alla momento. Thank you.
Thank you, sir. Advocate Ganesh Chandra. Thanks for coming all the way from Chennai. And
sharing your notes. Thank you, sir. Mr. Raji Dwivedi, sir. Thank you. Mr. Indra Vijay, representing IITR, is coming from Kerala. Thanks for being here. Thank you.
Yes, sir.
Light reach ಆಗಲ್ಲ ನನಗೆ. Come closer. Oh. Yeah.